Supplementary cause list 1 for judgment from 1 to 11.
Mr. Counsel, we have framed 4 points for determination. The first point for determination was whether the learned single judge was justified in setting aside the notification dated 28/1/1965 made under Section 14, read with Section 21 of the Act of 1955. The second point was whether the learned single judge was justified in setting aside the impugned order dated 5/8/2016 passed by the Chief Secretary to the Government of Government of Mizoram. Number 3 was what is the effect on award number 6/2003, supplementary award number 6/2003, as well as the award number 4/2002, award number 5/2002, award number 5/2003, if the points for determination number 1 and or 2 are decided in favor of the appellants. Number 4, whether the learned single judge was justified in relegating the petitioners in the batch of writ petitions to seek alternative remedy for execution of the awards in accordance with the procedure prescribed in the Act of 1894. And number 5 was what relief or reliefs the parties herein are entitled to. We have held that we set aside the observations, findings, and directions of the learned single judge in the impugned judgment and order dated 27/1/2021, whereby the notification dated 28/1/1965, which was published in the Assam Gazette on 19/5/1965, was set aside and quashed. Number 2, as regards the second point of determination, the setting aside of the order dated 5/8/2016 passed by the Chief Secretary, Government of Mizoram, via the impugned judgment and order is not interfered with, however, for different reasons as assigned. Number 3, we hold that the awardees of the award number 4/2002, award number 5/2002, award number 5/2003, award number 6/2003, and supplementary award number 6/2003 are entitled to the amounts as made in the awards. The state of Mizoram is statutorily obligated to make payment of the said awards. We further held that the state of Mizoram is directed to pay the awardees of award number 4/2002, award number 5/2002, award number 5/2003, award number 6/2003, other than the beneficiaries of the supplementary award number 6/2003, which would include the petitioners in WPC number 135/2023, 132/2000, it will be 13, I suppose. There's something mistake. 13. 132/2033, 2013, 130/2013, 118/2015, 131/2013, 117/2015, 116/2015, 16/2014, 22/2014, and WPC number 51/2017. Their entitlement as per the awards along with interest in terms with Section 34 of the Act of 1894 within a period of 3 months from today. In respect to the awardees of the supplementary award number 6/2003, that is the writ petitioner in WPC number 45/2017, they would be at liberty to further proceed with the execution proceedings, that is the execution case number 13/2010. This court had not adjudicated as to whether the state of Mizoram or NEPCO or any other authority is liable to pay the compensation. However, taking into account the judgment of the Supreme Court in the case of Masram Supra, we have directed the state of Mizoram, which is a welfare state, and being constitutionally obligated to make the payment as directed above within the period stipulated. Then we say that the observations and directions made herein above shall not act as a bar to the state of Mizoram to recover the same from NEPCO or any other authority, if permissible, as per the Memorandum of Understanding dated 29/5/1996 and other negotiations entered into between the state of Mizoram and NEPCO and other authorities.
We're deeply obliged.
Item 12.
For the reasons mentioned in the judgment, we are of the considered opinion that the evidence on record regarding the identity of the present appellant as having been involved in the alleged offense is insufficient to come to the conclusion of his guilt. He is therefore entitled to benefit of doubt in this case, which we give to him. The impugned judgment is accordingly set aside, and the appellant is set at liberty forthwith, if not required to be detained in connection with any other case.
In that view of the matter, there was no violation to Section 148A of the Act of 1961 while passing the impugned orders. As such, the said impugned orders do not come within the ambit of the exceptions as settled by the Supreme Court, as referred to supra. It is the opinion of this court that both the writ petitions challenging the impugned orders dated 10/9/2022 in WPC number 7014/2022 and the order dated 31/5/2022 in WPC number 4975 do not call for any interference under Article 2 to 6 of the Constitution. Accordingly, this court do not find any ground for interference, for which both the writ petition stands dismissed, the interim orders passed earlier and vacated.
For judgment item 58 to 73.
Accordingly, the instant batch of writ petitions are disposed of with the following observations and directions. The impugned cabinet decision dated 27/6/2024, as well the impugned notification dated 29/6/2024 calls for no interference insofar as cancellation of the tender process for the period 2024-25 and the decision to incorporate a viable rate in the tenders. The impugned cabinet decision dated 27/6/2024 as well as the impugned notification dated 29/6/2024 insofar as granting of extension to existing lessee till new tenders are not issued runs counter to Section 105 of the Act of 1994 as well as Rule 47 of the Rules of 2002. And as such, the impugned cabinet decision dated so-and-so as well as the impugned notification dated to that extent are interfered with. The respondent authorities are directed to run the huts in question till finalization of the fresh tenders under the direct management of the concerned Anchalik Panchayat. The respondent authorities are directed to complete the fresh tender process upon finalization of the modalities at the earliest and preferably within 3 months from the date of the instant judgment. Yes, mentioning
Eight minutes, my lord. Item number 79, my lord, in today's list, my lord. I will be reading out, Guwahati.
79, what is there?
That, my lord, that harassment by police and the local MLA. I have taken the consent of other side also. So let him come after,
Item number 79, matter stands adjourned to be listed after 4 weeks.
and my lord, one more item. One I has been filed, my lord, for interim order in WBC number 5767 of 2024. They come on Monday or Tuesday, anyway, any day. First day,
When do you want it?
Tuesday, Tuesday,
No, not Tuesday.
Wednesday, my lord.
We'll have it on 6th of December.
Yeah, please, Your Lordship, I beg to mention item number 25, madam. This matter may be come up after 2 weeks, madam.
Item number 25 to be listed after 4 weeks.
Deeply of.
May I please? Well, if similar concept matter, CAB matter has not been listed along with that series, so let that matter come on Monday, man. CAB matter concept, similar concept matter, my lord.
TV,
Yes, that has not been listed along with that series, my lord.
not Monday, Wednesday.
May I please, Your Lordship? Lordship, I beg to mention item number 31, Lordship. Lordship, some time may be granted, Lordship. Lordship, we are in the settlement process. We are doing settlement with the petitioner. The settlement is going on. It's almost, it has been done. There are some calculations that has to be connected.
Item number 31.
31. The, petitioner, yes, petitioner counsel is there.
Yes, what is this? Is that the matter? Where some amount was to be, I asked them that you have to purchase it from you. Isn't that the case?
Yes, yes.
Now you want to grant an adjournment.
Want to adjournment, the matter is almost finalized. Only the dispute in regard to the rate of the compensation. Only that has to be finalized. Rate has to be finalized.
There has to be a purchase.
Yes, so they need more time, some more time.
So what do I do? Have it when?
2 weeks at least.
2 weeks won't help the problem. Let's have it on 22nd of January.
Yes,
It has been submitted by the councils appearing on behalf of the respondents that the matter is being, that the said respondent authorities are trying to settle the matter out of court. This matter again on 22nd of January 2025 for an update.
Okay.
date may be kindly be fixed, otherwise, date may be kindly be fixed, date. 26. Alright.
Item number 30, Angus Council is out of station due to some personal.
Item number 13.
30.
30. What is it?
Your Honor, I'm not the Angus Council. I'm not the Angus Council. I'm a proxy council in this case. He's out of station due to.
What
some-
years is the out of the? He was very much yesterday here.
Yeah, Your Honor.
Then
to-
when the
to-
matter is reaches, why he is not always here?
Honor, as he has informed me that due to some.
Don't,
problem.
no proxy counsel. If he doesn't appear, we'll dismiss for default or look into it. Next,
May it please your lordship,
come
I
up
beg
a
to
proxy counsel.
item number 15. I have taken consent of the other side. My senior is not feeling well.
Item number?
15.
Yes, when do you want it?
Next week,
Item number 15 to be listed after 6 weeks. The request of.
May I please, Your Lordship? My lord, I beg to mention item number 48 of today's list, my lord. That this matter already in Coxas, my lord. It was on consent
Your
matter.
name?
Item 48,
What is your name?
G.U. Ahmed.
Mr. G.U. Ahmed, the learned counsel submits that the writ petition has become infructuous. So taking into account the above, the writ petition stands closed as an infructuous. Interim orders, if any, stands vacated.
Yes, sir, my lord.
Yes, Mr.
Lordship, item number 36. Can it be possible for the day, Lordship? I have to leave the court because of certain medical.
Okay, item
emergency.
number 36 to be listed after 4 weeks.
Lordship, item number 80, Lordship. Can it be taken up next week, Lordship?
Item number
80, Lordship.
80. Item number 80, at the request of the council, appear matter be listed after 6 weeks.
Next week, Lordship. I have
Absolutely no.
Lordship, at 2, Lordship, today.
8 weeks. 6 weeks.
May I please, your lordship, with the consent of the other side, I beg to mention item number 20. The conducting counsel for respondent number 5 to 9 is out of station, so.
Item number 20, at the request of the council appearing on behalf of the petitioner, matter stands adjourned.
And for the petitioner, Lordship.
You are here for the respondent.
Lord,
You have objection?
no. Kindly get.
No date fixed. The request of the council for the respondent not objected by the learned counsel for the petitioner, matter stands adjourned to be listed after 6 weeks.
Any day after 1st December.
6 weeks. Next.
I beg to mention item number 34, my lord. Item number 34. Can be taken up next week.
Item number 34, at the request of the council for the petitioner, matter stands adjourned to be listed after 6 weeks. Next.
I'd like to mention item 45. It has become infructuous, Lordship.
Item number 45, it has been submitted by the learned counsel, Mr.
The last name, M.K. Chaudhary.
What is your name?
Onjuru K. Chaudhary, M.K. Chaudhary.
Mr. M.K. Chaudhary, that the writ petition has become infructuous, taking into account the above, the writ petition stands closed as infructuous, interim orders, if any, stand repeated.
Item number 1, what are no steps?
Kindly pass over the matter for the time being.
Why?
Lordship, Mr. R. Shokia is coming.
What?
Lordship, Mr. R. Shokia is coming. He is in staff
Oh, what?
traffic.
Why he has not taken steps?
Lordship, I'm not involved in this case. He suddenly
You are
instructed
not
me.
at liberty, then we dismiss it. The records reveals that no steps have been taken against the respondent number 6, 9, 13, 14, 15, and 16, in spite of various opportunities being given. First, taking into account the names of the respondent number 6, 9, 13, 14, 15, and 16 are struck off from the records. First, the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of the court on the basis of the instant order within 3 days. The registry shall, on the basis thereof, make necessary correction of the records and also update the same in the CIS. Full stop. Failure to do so, this court, the matter be again listed before this court for further orders.
For implement, item 2.
In this case, my lord, copy of the implement petition was not served on me. I am the petitioner.
Yeah, and some minor probably by mistake, the clerk has not submitted.
I have verified on records, my lord.
What is this matter about a writ petition concern? What is your case, Mr. J.M.A. Chaudhary?
My lord, my case is that, my lord, the registrar has passed an order.
Huh?
Registered, I am against the order passed by the registrar in violation of the Assam Cooperative Societies Election Rules 2019, 27, Rule 27, and the, my lord, Section 49(2) of the Assam, my lord, Cooperative Societies Act.
Then?
This is my case. Order is, my lord, 2 order. One is Annexure 8, page 52.
Lecture
52, page 52, my lord.
19.7.
Yes, my lord. This is the order in review. And before that, my lord, an order was passed. That is in page,
Now, this is not an order appeal, this is not a review order,
my lord,
this is the appeal.
it says, my lord, starts with appeal. But this is under Cooperative Societies Act 1112 of the
You are
Assam.
a secretary,
My lord, register. Register, I'm the secretary.
you are a secretary.
Yes, sir.
What right do you have? What right do you have?
My lord, that is my case. There is
And who are you? You are the new board, new board.
Board of the members of the board, Lordship. Yes,
You want,
members of the board, Lordship.
shareholder, my lord, not member. Board is not there.
Shareholders.
One man committee is running the
Earlier
affairs.
it was there.
one man committee is running,
One man committee.
Isn't it one man committee is running the affairs of the
one man committee. Okay, they want him to be out.
Lordship?
And what is your steps? What,
Other
why
than-
you have not till now held the meeting? This
other-
happened in 2023. Your time is only for 90 days.
90 days.
What are you doing? Why they till now, there's no elections?
No elections have been conducted.
Why? We asked the register to remove you, have somebody else. Who is that one-man committee? It is not done. And who has suspended you?
My lord, pursuant to a police case,
Hmm.
I was suspended
Why?
by the, my lord, one-man committee. Then election was held. In that, after election, my lord, my suspension, I filed an application before the board of directors. My suspension was withdrawn by the board of directors. My lord, my authority is the by the board of directors. Thereafter, my lord, what happened? Some of the, my lord, aggrieved party filed an application before the register. Much after the AGM election, my lord, about the illegalities in violation of section 27, my lord. After 4-5 months, they filed the representation. That is in violation, lordship is our rule 27. Within 3 days, they have to file. They filed it after they approached the court, withdraw the writ petition, they approached the register. Register has passed an order saying that, my lord, my reinstating order is bad. So
By
my
the board of directors?
yes, my contention is that under section 49(2) of the Cooperative Societies Act, it is the board who has to decide my fate.
38-2.
49, 38, 38. And my lord, what happened? My lord, against the resolution, section, interesting point is that section 111 speaks about appeal against the order of the, my lord, departmental authorities or liquidator. 111. Against the lordship 100x. I'm reading out, man. Except where otherwise expressly provided to the contrary, an appeal shall lie to the register from the decision made under this act or framed thereunder by any government officer, liquidator appointed under section 95. So, my lord, my case is that against the resolution of the board of director, my lord, appeal do not lie before the register.
What?
Section 111.
What about 2L? 49 2L?
2L, my lord, any dispute between the, my lord,
The chief executive and the board?
chief executive, this is not the chief executive of the board, my lord. The
You are the
outside-
chief executive
I'm the chief executive officer.
and the board will be the one man.
No, my lord, one-man committee has suspended me. Thereafter, my lord, the election, AGM election was held. Board came into existence. I filed an application before the board of directors, board, to, my lord, reinstate me. Accordingly, board of directors has reinstated me. Against the order of the, against my reinstatement by the board of directors, they filed a representation before the, my lord, register.
Ah.
That cannot be because,
Who filed?
my lord, some of the shareholders. Yes, and that too,
Then
They-
why they shouldn't be made party then? Answer is that. That is what I was asking.
yes, madam.
So you don't have objection.
Yes. Yes. Okay.
Mr. M.H. Amit, the learned counsel appearing on behalf of the petitioner, Mr. J.M.H. Chaudhary, the learned counsel appearing on behalf of the respondent, petitioner, and Mr. G. Bordler, the learned counsel appearing on behalf of the corporation department. This is an application filed by the applicants herein, who are the shareholders of a society in the name and style of Luxona Bori Somobhai Committee Limited. Full stop. It is the specific case of the applicants that it is the specific case of the petitioner, applicants that they have filed an application before the Register of Cooperative Societies against the reinstatement of the petitioner, and on the basis of the said application, the order was passed, which is impugned in the instant proceedings. Mr. J.M.A. Chaudhary, the learned counsel appearing on behalf of the petitioner, do not object to the said aspect of the matter. So taking into account the above, it is the opinion of this court that the applicants herein, the applicants herein are necessary parties to the accompanying writ petition. Accordingly, the applicant numbers 1 to 5 are impleaded as the respondent number 7 to 7, 8, 9, 10, 11 to the accompanying writ petition. The counsel appearing on behalf of the petitioner, Mr. J.M.A. Chaudhary, is directed to file a fresh memo of parties before the registry of this court within 7 days from today. And on the basis thereof, the registry shall make necessary changes in the cause title of the accompanying writ petition and also update the same in the CIS. I stands disposed. Writ petitioner legible. Mr. M.H. Ahmed, the learned counsel of appearing on behalf of the newly impleaded respondents, that is respondent number 7 to 11, submits that he already has a copy of the writ petition. He, however, submits that he may be given some time to file an affidavit in opposition. This matter again on 24th of January 2024. The affidavit in opposition be filed by 20/01/2025. 24th of January 2025. Be filed on 21/2025, and the petitioner thereupon would be at liberty to file the reply if so advised.
My lord, only thing is that they have not supplied copy of the, my lord, IA. I could not.
Forget about that. You also did not supply a copy of the writ petition. I've taken care of
My
that.
lord, now he is going to, I have to, my lord, I have to correct the, my lord, first title. For that, my lord, implement. I'll provide.
Item 3,
You make it.
Lords,
You make the memo, give it to him, let him file it. Yes, what is this?
Yes, my lord, pursuant to the last order, my lord, we are filing I for implement of the finance department as well as the judicial department. My lord.
Okay. This is an application filed by the petitioner seeking directions to, seeking leave of the court to implead the respondent number, to implead the opposite party number 6 and 7 to the instant, to the instant application as respondent number 6 and 7 to the accompanying writ petition. Full stop. The respondents, however, the respondents have not objected to the same application. Full stop. Accordingly, the opposite party number 6 and 7 are impleaded as the respondent number 6 and 7 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties within 3 days from today, and within 7 days from today, and on the basis of which the registry shall correct technically liquidated. Next. Who is appearing for finance? Anybody finance? Is a finance counsel? You are finance?
On behalf of Mr. B. Gogol.
Miss P.
P. Gogol.
Borua. Who is Miss P. Borua, who is present in the court, accepts notice on behalf of the newly impleaded respondent number 6 and Mr. B. Bokolia. B. Bokolia accepts notice on behalf of the judicial department. Who is judicial? Judicial, any special counsel? No. You can accept. The government advocate accepts notice on behalf of the judicial department. So extra copies of the writ petition be served upon them during the course of the day, within 3 days after making necessary corrections. the state councils submits that they would request some time to obtain instructions and file the affidavit. List this matter again on 5th of February 2025. In the meantime, the affidavit in opposition be filed. In the meantime, the respondents, the newly implemented respondent number 6 and 7 shall bring on record their stand by filing the affidavits. Itu second order to
Supplementary item 84, bail hearing BA.
how much time?
My lord, in compliance with your lordship's order, I personally visited the trial court to verify the records as well as to talk to the special public prosecutor who is conducting the case. Now, case is fixed on 1st of February of 2025 for evidence,
When?
1st of February. Now he proposes, I also advised him, they call at least 2 witnesses. Now he proposes to call 2 witnesses. One is expert, my lord, FSL from FSL, and another is another independent, my lord, Caesar witness is there. He also proposes to call him. Now that is the position. Now I also asked him, how much time you want to complete the prosecution case? He also cannot say.
You are the prosecution. You are the accused.
Lord.
You are appearing for all the accused there. You are appearing for the accused. There is no quarrel with the proposition that you are not appearing. You are appearing. I've seen those order sheets. Mr. A. Ahmed is appearing in golden letters out there.
Yes,
So you are
in
appearing.
High Court, I am appearing.
In trial court.
In trial court, different
We
counsel.
pass an order today. I'm going to have this matter again. Although I'm in Kohima, I'll ask the registry to list it before me. I'll have this matter again on 9th, 10th of December.
10th of December.
I request the trial court to postpone the date. Fix a date nearer to February. Of December, another for these witnesses. On one hand, this person is languishing in the jail and you
Yeah.
want to have it in the month
And
of
only
February.
4 witnesses are there in the charge sheet.
No,
That
but
I
this
understand.
can't happen like that. I think this is a better way.
Before the
Because
date
once
to-
they are being done, then we can set you out. This court by an order dated 27/11/2024 had asked Mr. M. Das, the learned additional
D.
public
Das,
prosecutor,
my name is wrongly shown. D. Das.
D. Das, the learned additional public prosecutor, to give a positive timeline within which the evidence of the prosecution witness would be completed. Full stop. Mr. Dida, the learned additional additional PP, submitted that he had visited the trial court and could see the records that the next date is fixed on 1st of February 2025. Full stop. This court have duly taken note of that the petitioner herein have been languishing in the jail for the last 2.5,
She is in for 3 years, 3 months.
3 years, 3 months. Full stop. Under such circumstances, this court requests the learned trial court to fix a date. Request the learned trial court to, upon production of a certified copy of this order, to fix the date. To fix a date in the month of December for the purpose of further examination of the prosecution witnesses. Full stop. With the month of December 2024 for a year. Full stop. List this matter again on 10th of December 2024 for an update. Full stop. The registry shall also forward a copy of this order to the what court? Which court?
Additional session judge number 2.
Additional session judge number
Kamrup.
2, Kamrup
Metro.
Metro at Guwahati. Forfeit.
Publish.
Supplementary item 74 for admission part half.
the day before yesterday, the financial sanction was issued, so they will get it within 2 weeks then. A copy, I would like to place and one copy to the other side of it.
Mr. Digo Shakir, the learned Advocate General, Government of Assam, has placed before this court the financial sanction issued by the Medical Education and Research Department of the Government of Assam. He submitted that in view of the financial sanction already being granted, within 2 weeks, the petitioners are likely to receive the said amount. This matter on 3rd of January 2025 for an update.
Highly obliged.
Financial sanction is kept on record and marked with the letter F. XYZ MNO ABCDEF.
Still some are remaining.
Huh?
Out of
I
the
hope-
26,
I hope by the time the matter finishes, we don't,
I think
we are at
this
the
is
loss, we are at the loss of alphabets. And then we take up the alpha, beta, gamma.
Admission item 4,
like the vehicle numbers. Deeply obliged. Sir.
Yes, Mr. Monto, what is your case?
No, this is not my case, my lord. I am responding.
Huh?
I am for the respondent, my lord. We have
So,
the High Court, my.
are we to assume that you have, you don't have anything to
Yes, my lord,
say?
your lordship kindly see, my lord, order dated, my lord.
You also have a case? You also have a case from your side? Irrespective of
yes.
what they say?
My lord, your lordship kindly see order dated 21/7 by 2017. 21/7,
7, 2017.
My lord.
This matter is of 2015.
my lord.
The amount of it has been deposited with the area come collector by the respondent, thereafter further payment was deposited for making. What is the case of the petitioner?
Case of the petitioner, that land in Kharguli, that was acquired for the High Court, construction of the High Court quarters, my lord.
Ah.
So, we have High Court, my lord, paid it. It is acquired, government take it and they give it to us. We file our, give the payment to the deputy commissioner. Say, I have next, my lord. But the person who claim, my lord, he is not even the particular of that case, my lord. Because government acquired the land from the Inland Water Department. Because it is at that point of time, it was.
How
under
can
the-
you acquire land from the government? Can government acquire land from government? Is it
So now, my
Is
lord,
it possible? Is it possible to acquire land? Government can acquire land from government. Mr. Monto says. Isn't inland water transport a part of government? That day I became knowledgeable with the judgment of the Supreme Court in the case of something versus Reliance Industry, wherein it categorically says that the government cannot acquire its own land.
Experimentation of the present case. The regional department has filed an affidavit. It has been specifically pleaded that no land of the petitioner
has been acquired.
acquired for construction of judges quarter of Honorable Property High Court. Now that being the position against this my lord, there is no rebuttal. Number one. And number two, that notification.
Where is the petitioner counsel? Who are the counsel for the petition?
Earlier, the PM should read, then, my lord.
When did you file the affidavit? When did you file up the? So your specific case is that you have not acquired any land from the petitioner. And as such, if the petitioner is aggrieved, he should have therefore approached the authorities under rule section 18, isn't it? None appears on behalf of the petitioner on call. Mr. Arbo Pujari appears on behalf of the Revenue Department of the Government of Assam. Mr. T.J. Mohanto, the learned senior counsel,
Yes,
appears
number
on
three.
behalf of the Guwahati High Court. and Ms. M. Bormon appears for the district administration. The case of the petitioner hearing is that the petitioner a writ of mandamus be issued directing the petitioner to directing the respondent authorities to make payment of the compensation to the petitioner. It is seen on record that an affidavit has been filed by the Revenue Department on
File my lord. My lord, on the 3rd of April 2023.
on 3rd of April 2023, wherein it has been categorically mentioned that no land of the petitioner have been acquired under such, isn't it?
For construction of judges quarter
For construction of the judges' quarters at Kharbuli.
of this honorable court.
Why should I put this honorable court? Of the judges' quarter at Kharbuli. It is further seen there is no rebuttal to the same. So under such circumstances, it seems that the petitioner have lost interest in the proceedings, and as such, none has appeared on behalf of the petitioner. Accordingly, this court, on taking into account the above, closes the instant with petition on the ground of non-prosecution.
Item 5,
Yes, what is this, Mr. H. Sharma? What is this?
We have received the instructions, Lordship. From the instructions, it reveals that the patta was allotted to petitioner number 8 and 10 and one Sri Rajkumar Payang measuring 1 kata 5 lesser. Regarding the others, Lordship, they are not found in any occupation and there was no such any eviction also. This is the instruction, Lordship. May I place before Lordship?
Is that impugn order? Is that impugn order?
Mr. M. Sharma has been appointed as amicus, my lord. Well, Mr. M. Sharma has been appointed as amicus. He has,
Who has been appointed?
Mr. Maharshi Sharma.
Then,
My lord, he has been unable to attend this court this entire week due to ill health. He has requested me. to
why
be-
there is a requirement of appointing an amicus?
Because the briefs were taken back from the set of counsel for the petition.
So where is the question of appointing an amicus in these type of matters?
There's an order of this court. but
Who has appointed? It is VGLN. Mr. Sharma,
Lordship.
VGLN.
Yes, Lordship.
Where is the appointment of an amicus?
Uh,
M, so requested AR is the court petitioner are not represented here. Yeah, so you have not been appointed. Learned State Council has praised whether the petitioner has already been evicted or not, they are still occupying the land from which they have. Has the petitioner been evicted?
No, Lordship, no eviction. They were not in position.
Okay,
They were not in position. That is the instructions we have received, Lordship. Those two queries, Lordship, number one.
no, there is no appointment of an amicus, Mr. Council.
My lord, would kindly come to order dated 21 August 2020.
29 August,
21st of August 2020.
1st of August.
Last two paragraphs, my lord.
This court has requested in this case for which has readily accepted, registry to so furnish a copy. So there is no appointment or that day the court wanted. None appears on behalf of the petitioner on call. Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner, a respondents submits that the question of evicting the petitioner from dock number 91. 91, not
Lordship. Lordship.
dock number 91 isn't it?
Yes, Lord.
Dark number 91 did not concern dark number 91. 91 or what?
Yes, Lordship. From there, one cutter tender
Ah.
is covered by doc number 91 of.
91 of village Betpuchi, Moza Beltola, which is a government land, did not arise, taking into account that the petitioner is
And they were
in
not found
possession.
in occupation of that land.
Taking into account that the petitioner is not in possession. Full stop. He further submitted that as regards this, what has happened as regards the settlement? application?
Regarding that petitioner number 8 and 10 and one Sri Rajkumar Payang have been issued patta in their names for the land measuring about 1 kata 5 lesser each. That is the last line of my instructions, Lord.
In
Last three
addition to
lines.
that, he has submitted that
Petitioner number 8 and 10.
out of the 12 petitioners, the
8, 10 and 12, Lordship.
there are 12 petitioners. Out of the 12 petitioners,
Lordship.
petitioner number 8,
10 and 12.
10 and 12 have
Lordship.
already been issued settlement by issuance of patta,
Lordship.
by issuance of patta of a plot of land at measuring 1 kata 5 lecha each. In addition to another
No, Lordship.
person.
No, Lordship. That another person is 12, Lordship.
Okay.
Not 15.
Have already two, 8, 10 and 12. In that regard, he has placed before this court an instruction which is kept on record and marked with the letter X. In that view of the matter, this court, in that view of the matter, it seems that the petitioner have lost interest in the matter for which the instant petition stands closed.
Item 6,
Your Lordship, can they come
So
to?
you came for 6, that is why you jumped in item 5,
He requested.
something like that. That? Yeah, tell me.
Lordship,
What is
can they
this?
come to the order dated 21st of March 2022, the Lordship's order? Whether the
21st of March.
2022.
Oh, my order. Yes.
That affidavit, the affidavit in terms of the state order on 30th of September.
And what happened?
When they stated that there is a liability of total liability of 23 crore 76 lakh 75,677 million.
So you have filed the affidavit on 30/9/2024.
Yes, sir.
And
Before going to the annexure, Lordship, can they come to their para 6 of that affidavit?
affidavit,
These are the objections.
class 6. What is that?
Can we be allowed to read? No, this is in compliance of that order.
That on here, this court was directed to clarify the stand of the answer as regards the contention made in the exact numbers of cylinders It is required to be returned by. It will be highlighted. No, Have you filed a reply against this?
So, my lord, my instruction
So
today,
we admit it.
my lord, today my instruction is, my lord, instead of going to and fro, me giving numbers, him again coming back with it. Our officers are willing to sit for a reconciliation with their officers, my lord, in the High Court meetings.
Why?
And
There's so much of space
Because
in
I-
IOCL. Huh? IOCL, so much of space. Why do you need the
They're
High Court
most
building?
welcome
My
in our
lord,
office, my
the
lord.
first query your lordship was put, my lord, how the liabilities will be met up, my lord. That in that regard, my lord, lordship will see annexer D at page 65 of that everything.
It's
might perhaps
65 of what?
My lord, my lordship will be reading. my lord.
Yes.
We have sent a proposal and including the due of the petitioners also, my lord. Request some permission from the government. In turn, my lord, the Register of Cooperative Societies, he has placed the proposal before the government, my lord. Now the government is in the picture, my lord. Their approval is required, my lord.
Who's
The
government?
Cooperation Department, my lord.
Cooperative.
My lord, Cooperation Department.
That is a different thing. Here we are concerned about the returning of the
No,
cylinders.
my lord, that cylinder, in lieu of cylinder, the price, my lord. If the price is paid, my lord, some approval is required from the government.
We'll look into that later. on. First of all, he wants to sit with you and have a talk and finalize. Because you say that there are certain amounts of money which were paid to them also.
Yes, my lord.
And then for that, they should have appropriately adjusted against those cylinders. You say that there are many cylinders which those agency of yours against who had filed title suit and all, these cylinders, these people want to directly give it to IOCL also.
Right.
So there will be a requirement of some form of a conciliation. So sit somewhere else, not in the High Court.
They're most welcome in our office, my lord. It's a very big office in Mumbai, the head office.
Where? Where is your big office?
At Mumbai, my lord, it's a head office of IIT.
And where do you stay?
The office in the Register of Cooperative Societies. Assam.
From there, you take a flight to Delhi and come back, take a car, and then go to his office. Let him pay those.
Yes.
Okay, Mr. P. Bharadwaj, the learned counsel appearing on behalf of the petitioner submits that pursuant to the affidavit filed by the respondent number 1, the IOCL authorities would like to reconcile, would like to have a conciliation sitting with the respondent number 1 at an appropriate place as directed by this court. Has been submitted by the respondent number 1 that by the petitioner that the respondent, the official liquidator can very well have a meeting in their office at Nunmati, to which Mr.
P. Hazarika.
Lorenzo P. Hazarika has submits that has no objection. So stop taking into account the above, list this matter again on 5th of February 2025. In the meantime, the respondent number 1 as well as the petitioner shall take due steps for reconciliation of the accounts, reconciliation in terms with the affidavit dated 30/9/2024.
Item 7.
That concurrence of the government for payment like
And
this.
see, once you reconcile, then only the question will payment come, then we may have to bring the corporation department.
Public.
Item 7.
What is this?
Actually, this matter has become influx of money.
Mr. P. Burwa, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous. Accordingly, the writ petition stands closed. Interim order, if any, stands vacated.
8.
My lord, in this matter, my lord, charges has been submitted long back, man. Itu dada.
Pursuant to the order passed by this court on 31/11/2024, Mr. G. Bokolia, the learned government advocate, have placed before this court the charge sheet which was filed
30/01/2020.
in connection with which case? Connection with Bilasipara PS case number 1469/2018 on 18/12 on 31/2020. Full stop. Taking into account the above, full stop, the said charge sheet was produced pursuant to the order passed by this court, which is kept on record and marked with the letter X. Taking into account the above, the petitioners herein shall take appropriate steps before the state court. Before which court?
My lord, this session tribal case 460 is there, man.
Where is it pending? Huh?
My lord,
Where is it pending?
presently,
This charge sheet was submitted in 2020, you don't know. Where is it pending?
my lord,
Does it take 4 years? Is it the state of affairs in the criminal courts? Charge sheet you submit one day and whatever happens after 4 or 5 years.
the last, only we are taking the instruction regarding charge sheet, my lord, regarding the status of the case. Whatever.
It reminds me of a story once told by somebody, by King, asking his minister out there to go and find out what it is. And there is another person saying that I should be appointed as the minister. So both of them were asked to find out what was the state of affairs. The minister comes up with all the news. And that person comes up, oh, I didn't find out the other things. Something like that. When you are submitting the charge sheet on 2020, then does it take 4 years for the purpose of being committed?
Like that way.
Pursuant to the order passed by this court on 30/11/2024, the charge sheet have been produced. And charge sheet has been produced, which is kept on record and marked with the letter X. This court had asked Mr. G. Bokolia, the learned counsel appearing on behalf of the learned government advocate as to whether in which court the said case is pending. So he submits that he will take instructions in the matter, list this matter again on 18th of December 2024 for such instructions.
Item 9.
Then you don't say, come up with this, only that, full instructions.
May I please, Lordship? Lordship,
Yes, what is this?
Yeah, Lordship, we have received instruction from petitioner not to press the case any further, Lordship.
What is your name?
NZ Chaudhary. NZ Chaudhary.
NZ Sodri. You are there in the petition?
On behalf of Mr. Air, I am here. On behalf of Mr. Air.
Whose names are there in the cause list? You have filed your wakalatnama?
No, Lordship, on behalf of him, I am appearing.
Yeah, yes, sir.
ARVI is not here, na?
That is why he's under treatment. He's-
Medical treatment is outside of.
No,
We
the
are Mr.
problem
Bhuiya.
is, are you N.A. Mazar Bhuiya?
NZ Chaudhary.
How are you connected with the AR Bhuiya?
I'm associated with his chamber, Lordship.
You have any document to show?
Written instruction from
Because otherwise tomorrow somebody may file a case against you in the bar council. Mr. What's your name?
NZ Chaudhary.
NZ Chaudhary. The learned counsel who is learned junior of Mr. A.R. Bhuiya submits that the petitioners have instructed to withdraw the instant writ petition. In that regard, he has placed before this court a communication dated 29/11/2024. Is it one petitioner or petitioner? The petitioner, as instructed. Taking into account, has also placed before this court a communication whereby the petitioner had duly informed Mr. A.R. Bhuiya, advocate, for withdrawal of the case. The said communication is kept on record and marked with the letter X. In that view of the matter, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Much obliged.
Item 10.
And appears on behalf of the petitioner on call. It is seen that on the earlier occasion also none has appeared on behalf of the petitioner. Taking into account the above, it seems that the petitioner have lost interest in the matter for which the writ petition stands dismissed for non-prosecution.
11.
Yes, what is your instruction?
Instructions is that Lordship, the LR staff has surveyed the area, Lordship, and it was found that those villages are not there. It was eroded in the year 1980 and 1980, Lordship, and in 1990, some portions of two villages came into surface as Balisor. As mentioned by the petitioners, that they are residing there since 1936-37, but as per the record and field verification, there is no such residential proof or specific position over the land is found in the claimed area except 5 numbers of Tara Bamboo Saligor.
What about village Molatari?
It is not specifically mentioned here, but this is the verification of the LR stuff, that is the paragraph 5. Just Lordship, let me verify one.
None appears on behalf of the petitioner on call.
Villages
Is
mentioned
seen-
in the writ petition.
It's seen on records that the petitioners have applied for allotment of pattas. The petitioners have approached this court being aggrieved by the inaction on the part of the respondent authorities in not allotting the settlement to them in respect to village in 1336/37 at village Molar Mollartary and Kazlortari, Kazlartari, under Polaswari Revenue Circle in the district of Kamrup, rural Assam. Pursuant to the order passed by this court on 16/9/2024, Mr. H. Sharma, appearing on behalf of the district administration, has submitted an instruction. Where is that?
The paragraph 2, Lord.
That the lands mentioned in the writ petition could not be surveyed as because the villages mentioned in the writ petition were submerged in the river Brahmaputra due to river erosion in 1980. And again in 1990, some portion of the two villages came into surveys as Balisor. It was also mentioned that the fact that the statement made in the writ petition that the petitioners are residing there since 1936-37 cannot be true. Inasmuch as per the record and field verification, there is no such residential proof or specific possession over the land found in the claimed area, except 5 numbers of Karabambu, Talighor. Taking into account the said instructions is kept on record and marked with the letter X. But in view of the said instructions, it seems that the petitioners have taking into account the said instructions, this court would not be in a position to issue a writ directing the respondent authorities to consider the case of the petitioner for settlement as sought for in the writ petition. Be that as it may, accordingly, the writ petition stands dismissed. Be that as it may, the dismissal of the writ petition shall not prejudice the petitioners to seek settlement in terms with the Assam Land Policy 2019 if they are otherwise entitled as per the said policy.
Well,
What is this? And appears on behalf of the petitioner on call. Seems that the petitioner have lost interest in the matter for which instant petition stands dismissed for non-prosecution.
13,
What is your case?
The reduction I have challenged, my lord, the order passed by the Honorable Revenue Board, my lord, page
Huh?
93. An order is page 93, my lord.
What are you challenging? 18-3 year passed by whom?
Revenue Board, my lord.
Board of Revenue.
Yes, my lord. Yes,
What is the order? Let us see.
page 93.
Appellant advocate is present in the previous date, heard learning counsel for both the parties on the issue of impleadment of Gopal Rai and Amir Rai as the following in the instant appeal, peruse the petition against the impleadment claim made by Yes. What is wrong? Why you're not filing a review? Your application categorically says some other DAG number.
But the issue is not the DAC or Yeah, my lord. My lord, the respondent 7, 8 and 9, my lord, filed that appeal against the order of the settlement officer, my lord. Before the settlement officer issue was, my lord, during the last settlement operation, my lord, a patta was issued in favor of the private respondent. They file an application for correction of that patta because a tenancy is included in that patta. The tenancy by which order the tenancy was created, my lord. Tenancy was created, my lord, in respect of 3 persons, my lord. This petitioner number 1 and 2, and they sought correction of the record, my lord, and that person, my lord. My lord, if you lordship kindly see the order which was passed by the settlement officer, my lord, that is at page 86.
I'm only asking, where is your petition? Is your application for impleadment?
That I am not annexed.
Your application for impleadment you have not enclosed. This type of case. Isn't the entire issue based upon your application for impleadment being not allowed?
I may be allowed to say that. File an additional 300.
Why the matter has been listed?
My lord, in earlier occasion, my lord, the private respondent was mentioned, my lord, this matter for listing.
You mentioned the matter.
No, respondent,
Was there a stay?
yes.
Huh?
Yes.
We get the stay. You are stopping here.
My lord,
Who is appearing for the respondent?
but apart from this tenancy, my lord, tenancy order, my lord, there are other tenancy by which we are also tenant, my lord. That tenancy has been already upheld by the revenue board in recent revenue appointment. There are other.
From the record, it is seen that the impleadment application has not been brought on record, on the basis of which the impugn order dated 18/3/2019 was passed. In addition to that, the private respondents are also not present. Taking into account the above, list this matter after 6 weeks.
14,
The matter has been taken up by the municipal board. And the last date was fixed on 7/8.
8/11.
My lord, it could not be taken up because
Last date was fixed on 8/11.
8/11/2024.
What happened?
And that too, it was the MCC was on Old My Lord in the Kachar district till 23/11/2024.
Why is the executive officer taking up the matter?
That is what, my lord. This matter was never entrusted to the Silsor Municipal Board again, my lord, by the Honorable Court. On my learned senior counsel suggestion, my lord, it was being, sent back for a fresh hearing. Whether, my lord, in earlier round of litigation, my lord, there is clear order of this Honorable Court to, my lord, adjudicate the issue by the chairman, Silsor Municipal Board. And, my lord, Silsor Municipal Board deliberately.
But now you have a board.
Yes, my lord.
Yes.
What is this executive officer doing?
No, yes, executive officer is function, elected body is not there. Elected body is not there.
Oh. My instruction, my lord, it's there. I've been told, my lord,
So election is there.
election to be happening in February, my lord.
He submitted that now what has the executive officer done? Why he is not deciding it?
So, my lord, the last date, because the MCC was in operation because of the election and all that. So it was up to 23/11 only. So now I think in the first week of December, they will be.
MCC can happen only till the results the
Yes.
elections are here.
The result was on 23/11.
Result has nothing to do with MCC.
Anyway, the election was in the process.
So-
Therefore, MCC was in operation.
MCC only operates till the date of the last voting.
Yes.
Then
So the date was fixed on 8/11. Before that, my lord, it was in operation.
Then Now,
Anyway, my lord, I think they'll be taken up in the first week of December.
we direct them to take it up.
Yes, may I submit, my lord?
We direct the executive officer to do it on or before 10th of December, and thereupon submit the order before this court by 7/16.
But may I submit? My lord?
Yes, please, Samno.
Kindly come to page 46, my lord. Just for a minute, my lord. 46. The earlier round of litigation, my lord.
Yes.
At the last paragraph, my lord, paragraph 14. May I read, my lord? Accordingly, it is directed that the chairman, Chisholm Municipal Board shall give a due consideration to the complaint filed by the petitioner against the response number section 7, as well as the complaint filed by response number section 7 against the petitioner, and as indicated above, pass an appropriate order thereon. The aforesaid exercise be carried out within a period of 3 months from the date of receipt of a certified copy of the judgment and order. In terms of the above, the writ petition stands disposed of. Then, my lord, we went to them, my lord, at the impugn order, my lord, page 150. Last
Page?
page, my lord. 152 is the impugn order, 152.
Yes.
152 is the order, my lord. We took part in a hearing, my lord, detailed hearing. After hearing, this order was passed. May I read the last portion as 154, page 154, my lord. Kindly see, my lord, the audacity of the chairman, my lord.
So even after the order being passed by this court, chairman says that why should I decide, because my predecessor had already decided.
I cannot review the order. That is her statement. Your lordship kindly see the last thing.
But the problem, there is a problem, Mr. The problem is we have to be very careful while passing our orders. Whether that order, earlier order was set aside.
Sir, sir. Correct. Earlier order. Simply send it back.
Is the problem, na?
Yes, yes, correct. That I agree, one, but what happened in this case, my lord, this is matter is pending, my lord. So I am, the lordship kindly see the, since 2019 case is pending. And I am fighting with the mighty, my lord, that was, I am simply, I am. When
You're
once
fighting whom?
your lordship kindly see the neither respondent number, private respondent nor Silchar municipal report till today, no affidavit is filed here in this case. Not since 2019 case is pending. The violation is admitted, there is a clear violation, but we cannot do anything.
There is no violation per se, taking into account that you have not set aside the order. He has passed an order. Said, how do I reconsider my? You can only pass an order when it is set aside.
Yes. So since, my lord, there is a instruction passed by, there is a direction passed by this honorable court. You start from page 42, my lord, and read the.
To reconsider.
Yes,
The language is to
Reconsider.
reconsider. So he says that how can I reconsider? I can't review. You can't create a jurisdiction under Article 226. So the direction should have been, we set aside this and direct them to look into again, isn't it? If that order would have been given, they would
Yes.
have been bound.
but now, my lord, for that I should not be, my lord, at least now they can.
So the question therefore is, when the chairman is not there today, don't you think that the executive member can decide? Because the executive member takes the air of the board
My lord.
to the,
No, then, my lord, your lordship kindly, here, my lord, your lordship kindly, let them file an affidavit, why they have not done it? And the matter may be decided here, my lord, because there the violation is apparent,
what has happened?
my lord.
What has happened? What is the violation?
Violation, my lord, page 39, my lord.
So they have not filed affidavit.
Right.
So we'll go by the doctrine of non-traverse. Don't worry. No problem. If it is, we'll say that whatever you say is to be admitted. Take it as a gospel. What is the violation?
Page 39, my lord. Your lordship can see.
Page
39.
9.
Okay, no?
Yes. Sir, Doctor, what do you say on page 39?
Lord, your lordship, can we see if there is a violation in terms of the general regulation? Lord, that violation would be inquired into by the executive reserve.
No, if you are not taking any action, why shouldn't we take it?
Lord, the last occasion when it was pending like this,
No, we are not concerned. We take it, this is this. If there is a violation, he has not filed any affidavit. So we immediately direct you to demolish. Whereas within 7 days, you demolish them. No affidavit filed, nothing is there.
because there is a, as per the zoning regulation, they 10%, my lord, they
10%, how can the 320, maximum allowable is 320, how can it become 558?
50%, my lord, then 91%.
80% is okay, but far maximum is 320. Let us take another 10%. It will be 355. So how can it be 558? You have not filed the affidavit, so we take it that you have nothing to do.
10 days, my lord.
Not 10 days, Monday. Monday file the affidavit by both of you. Nothing doing.
My lord, what I submit.
No, there's nothing to submit. Because what you have done is absolutely illegal. It seems that the Silchar Municipal Board or the executive officer is in hand in glove with response number 6 and 7.
That, my lord, of course, it appears to be.
Eh?
If your
If it
lordship,
is appears to be, being a senior counsel, you can't defend them.
my lord, I'm not trying to defend at all. What I'm
Why
saying
they
that-
have not till now?
What I'm
You have
saying-
understood the purport of the order passed, which was passed by on the earlier round of litigation. Everybody knows that when there is a direction for reconsideration, yes, on so many words, it may not have been mentioned that we set aside this. When there is a direction for reconsideration, you have to look into it. Sometimes courts are very benevolent enough to use not harsh language. If we use harsh language to the effect that we set aside this is absolutely not contrary to the year, and we direct you to again look into it in this language, if you put it, I think then the authorities understand. Not in a subtle tone being given to kindly reconsider. No, reconsideration of the matter.
No, your lordship is very correct, my lord, and I'm telling your lordship, if these are the things really, and I hope.
Why is he not? What is the problem about MCC or anything with an order to be passed? When a matter has been pending, when you have informed this court that he is going to take up on 8/11, how does MCC come into the being?
my lord,
MCC doesn't come into the being. You are not issuing any contract to anybody. Are you saying because of MCC, you have not passed a single order, not used any of the resources of Silchar Municipal Board during this period? Should we ask you to provide all the details what has happened from the date on which the notification for election was issued till the date on which the results was issued?
my lord, your lordship can do
Don't
one.
come up with this type of excuses, Mr. Doctor.
I'm not much on that. Only thing what I'm saying, your lordship.
We won the order passed the order by 10/12/2024.
Yes,
Produce it before me on 16/12. I'm giving it.
right.
Regarding court cases, MCC is not applicable, my lord.
No,
Code
we
of conduct, my lord.
let the order
pending
be
cases,
passed
my lord.
on 10/12. If they want a hearing, fix it on 5th.
Yes.
They give them a hearing, both sides. pass the order and produce before this court on 16/12.
Exactly, my lord. That's
PM.
my lord.
Heard Mr. T.J. Mohanto, the learned senior counsel, appearing on behalf of the petitioner. Mr. S. Doctor appears on senior counsel, appears on behalf of the Silchar Municipal Board, appears on behalf of the respondent number 2, 3, 4, 5. Mr. G.N. Sahewal, the learned senior counsel, appears on behalf of the respondent number 6, 7, and 8. Appears on behalf of the respondent number 7 and 8. It is seen that both the petitioner as well as the respondent number 7 and 8 have filed complaints before the chairman of the Silchar Municipal Board. As regards certain violations to the buildings constructed by them. The record further reveals that the Deputy Director, Town and Country Planning, Silchar, had also opined in a report dated 15/7/2013 that the respondent number 6 and 7, 7 and 8, while carrying out their building, while constructing their building, have exceeded the maximum coverage of the commercial building from 80% to 91%. It was also opined that the maximum allowable FAR floor area ratio it was 320, but the floor area floor area ratio of the building, commercial building of the respondent number 7 and 8 was 558.03, which was against the norm. On the basis of those complaints so filed, an order was passed on 2/1/2014 by the chairman, Silchar Municipal Board, which was the subject matter of WPC number 198/2014. In addition to that, there was also another order of the chairman, Silchar Development Authority, as well as the appellate authority, dated 8/12/2008 and 2/8/2010 respectively, which were subject matter of another writ petition being WPC number 4651/2010. Both these writ petitions were disposed of by this court by an order dated 30/8/2017. Whereby the coordinate bench of this court observed that as the core issue was as to whether there was any violation of the building laws by the respondent number 6 and 7 have not been decided. it would be better that the matter be remanded back for fresh consideration by the chairman Silchar Municipal Board of the complaint raised by the writ petitioner herein. It was further mentioned that the chairman Silchar Municipal Board shall give an opportunity of hearing to both the party petitioner as well as the respondent number 6 and 7 and allow them to produce all relevant materials that may desire to produce. So, paragraph number 11 to 14, 15 of the said judge order being relevant is reproduced herein under. The record further reveals that pursuant thereto, an order was passed on 30/5/2019 by the Silchar Municipal Board, by the chairman of the Silchar Municipal Board, under memo dated 6/6/2019. From a perusal of the said order, it reveals that as in the earlier order, there was a mention that the construction was made by the respondent number 6 and 7 as per the construction permission. The objection submitted by the petitioner was rejected. There was no case made out to review the order passed by the earlier chairman of the Silchar Municipal Board. It was further observed that by the chairman of the Silchar Municipal Board that there was no scope to reopen the episode, at least by the authority, and the complainant and the petitioner herein was given the liberty to approach the appropriate higher authority. The order dated 31/5/2019 and the memo dated 6/6/2019 has been put to challenge before this court. Mr. T.J. Mohanto, the learned senior counsel appearing on behalf of the petitioner, submitted that a perusal of paragraph number 11 to 15 of the judgment dated of the judgment order of the judgment dated 38/2017 categorically mentioned that there was a requirement for a fresh consideration and the matter was remanded back. The learned senior counsel submitted that it is a well-settled principle of law that when the matter is remanded back, it amounts to setting aside the order, which is the subject matter, before the court. And therefore, there is a requirement for a fresh decision in the matter. The learned counsel therefore submitted that the chairman Silchar Municipal Board would not have submitted that the chairman Silchar Municipal Board not only abdicated his duty cast upon him by the Assam Municipal, Assam Municipal Act 1956, but also the specific directions passed by this court in the judgment dated 38/2017. And as such, there is a requirement for an interference. It is noticed that this court had issued notice. It is observed herein that this court had issued notice on 9/9/2019. The Silchar Municipal Board, as well as the private respondents, have duly appeared before this court in connection with the instant proceedings in the year 2020, as on 16/12/2020. Even after a lapse of around 4 years, no affidavit has been filed to contest the case of the petitioner. In the backdrop of the above, to dispose of or not?
Sitting aside that order.
Oh, that I'm sitting is.
My lord.
They keep it, then it will get demolished.
Violation which speaks whether it's a case of demolition.
Anyway. Having heard the learned counsel appearing on behalf of the petitioner and taking into account the above quoted judgment and above quoted paragraphs 11 to 15 of the judgment dated 38/2017 passed in WP by the coordinate bench of this court, it apparently appears that the order dated 35/2019 by the chairman of the Silchar Municipal Board, which was under memo dated 6/6/2019, was on the face of it erroneous. This court has arrived at the said opinion, taking into account that the earlier orders, which were the subject matter of writ petition, WPC number 198 and 45 something. 198/2014 and WPC number 4651/2010. Were impliedly set aside by this court when there is a direction for wherein there was a direction for remand and fresh consideration. Therefore, the chairman, Silchar Municipal Board, was required to decide the petitions so filed by the respondent number 7 and 8 herein against the petitioner, as well as the petitions so filed by the petitioner against the respondent number 7 and 8 herein, afresh without being influenced by the observations so made in the earlier order dated 2/1/2014 passed by the chairman, Silchar Municipal Board. Accordingly, the order dated 35/2019 passed by the Silchar Municipal Board, Chairman Silchar Municipal Board, and the memo dated 6/6/2019 is set aside and quashed. is liable to be interfered with. Liable to be interfered with. This court further finds it that in spite of that, in view of the setting aside of the order dated 35/2019 of the chairman of the Silchar Municipal Board, there is also certain requirement for issuance of certain directions for completion of the process, the completion of the hearing within a time frame. Accordingly, the instant writ petition stands disposed of with the following observations and directions. Number one, the order dated 35/2019 passed by the chairman, Silchar Municipal Board under memo number NP/BP/V/06/2019-20/1457-1458 dated 16/6/2019 is set aside and quashed. Number two, the chairman, Silchar Municipal Board, and in absence of there being the chairman, the executive officer so appointed under section 52, appointed under 51, 52. Mr. Monto.
Correct.
53, na? 53
Just a minute.
of the Assam Municipal Board, so appointed in
53.
terms with section 53 of the Assam Municipal Act 1956 is directed to decide the complaint filed by the petitioner against the respondent number 7 and 8, as well as the complaint filed by the respondent number 7 and 8 against the petitioner, without being influenced by the order dated 2/1/2014 passed by the chairman, Silchar Municipal Board, as well as the impugned order dated 35/2019 passed by the chairman, Silchar Municipal Board. Number three, the chairman, Silchar Municipal Board / the executive officer, Silchar Municipal Board, is further directed to decide those petitions, complaints in accordance with the provisions of the Assam Municipal Act 1956, as well as the building bylaws other than. Huh? There's no building bylaws other than that,
Yes,
that
yes,
apply.
Regulation.
But that was granted under town and country planning.
No, 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 no.
Now,
Development authority.
now it is under municipal board.
Now it is under, municipal, but the town and country planning.
The permission is okay, but you cannot deviate from there.
This is
As per the
under
building bylaws, what is the name?
Zoning regulation 2000.
Building bylaws other than, there's a mention other than Guwahati.
Other than Guwahati.
There is a building bylaws. What is that? Yes, Mr. Kostov Gogoi. You write a book and I've forgotten. What is that book?
The Assam notified urban areas other than Guwahati building rules.
Zoning regulation 2005. Yes. Zoning regulation.
And as well as the provisions of the so and so. Full stop. Next. The said decision, the said adjudication be carried out, be made by the chairman, Silchar Municipal Board / the executive officer, Silchar Municipal Board, within a period of 30 days from the date of submission of a certified copy of the instant judgment. Full stop. Full stop. The judgment to the Chairman, Silchar Municipal Board / Executive Officer, Silchar Municipal Board. While doing so, the petitioner as well as the respondent number 7 and 8 be heard, be given an opportunity of being heard. Next. Upon passing of the said order, the Chairman / Silchar Municipal Board / the Executive Officer, Silchar Municipal Board is further directed to file an affidavit of compliance before the registry of this court, enclosing the order so passed in pursuance to the directions, in pursuance to the above mentioned directions. Full stop. It is further mandated that the said period so directed be complied with.
Both the parties will cooperate without taking time.
Full stop.
We never take.
It is further directed that both the parties shall cooperate. Where is the order?
Annexure 1, page 18.
Finished.
That is the only order issue. Lordship peruse section
This is done under 33, scrutiny assessment.
33 is only scrutiny, only rectification of errors in the return. It doesn't levy, empowers him to levy any tax, interest or penalty. And there is also specific form under which notice has to be issued, which has not been done in this case.
Oh, better conduct. This is not, this is done under 30.
33. Section 33.
So did you submit your return?
Submitted returns. Okay. Yes. From the returns only he got this figure. The Lordship turns to page 19. The first line he is relying upon the aggregate turnover return. From the return he has taken out these figures.
Hmm?
Page 19, Lordship.
Where is your return?
That we have not annexed.
Unnecessary.
We have against the implement orders.
How do we know whether you filed it or not?
Not the case of the respondents that we have not filed a return. Not the case that we have not filed a return, since he has invoked section 33.
They have invoked 33, they may have wrongly invoked 33. How do we know that you have filed your return? You made a statement.
We have made it.
You at all submit your return? No. No statement. So they have exercised the power under 30. In written, writing all these things may be different.
The assessment order states that under section 33.
Maybe. Maybe a case under 30. 30 does not require. 30 does not require notice, hearing, nothing. And you have not made a single averment that this is that you had submitted your return, it would be a case coming under 34. 34, okay, you are to be heard. Then dismiss it on that ground. What is wrong?
Even if I take time for submitting of the returns, in that case, I'll take the instructions. I'll take the instructions to that copy of the returns in that case. But the assessment order apparently states that excise has been done under provision of section 33. Point number 5.
Because if you have filed your return, you would have definitely paid some tax.
Yes.
Here you see tax paid nil.
Yes.
That means they may have put it 33, but they actually exercise 30.
No, my return was nil because it's a tea we had exported, it was totally exempted. So it was nil. So far return is concerned, I'll take instruction, I can produce the copies of the returns.
Because there is not a single averment. You would have definitely said that I have filed my return, and therefore if they want to scrutiny my return under 33, 33 actually you don't do anything. You only scrutinize and tell him that kindly make these corrections. That is 33.
The department does this scrutiny.
So the department will ask you, I noticed that you see, we have looked into your return, we find that there are some deficiency, kindly correct it or pay this amount or year. If you don't pay then he will go for provisional assessment under 34 by issuing a notice. But 30 does not require anything. So under such circumstances, it couldn't have been passed under 33. 33 does not conceive of a return. What do you say? What?
Lordship is correct.
In that case, I may be granted time to furnish the copies of the written biography and affidavit.
Upon hearing the learned counsel appearing on behalf of the petitioner, Mr. Dr. A. Todi, the learned counsel appearing on behalf of the petitioner, submitted that the impugned assessment orders in both the writ petitions were passed without giving an opportunity of hearing to the petitioner. He further submitted that pursuant to passing of the order, there was also no notice issued as regards completion of the assessment, and it is only when action was taken under the provisions of the Bengal Public
Demand Recovery Act.
Demand Recovery Act 1913, the petitioners could come to learn that these assessments were carried out. He therefore submitted that the resort so taken under section 33 of the Assam Value Added Tax 2003 could not have been done without giving due opportunity to the petitioner. This court, upon perusal of the writ petition, do not find that there is any whisper that the petitioner had submitted a return. Under such circumstances, this court put a query upon Dr. Todi as to whether the assessment so made would not come within the purview of section 30 of the Assam Value Added Tax Act 2003. More so, taking into account that neither the earlier return so filed, earlier self-assessment returns so filed, or they have been brought on record, or there is also any mention in the pleadings that the petitioner had filed the return in terms with section 29 of the Act of 2003. Taking into account the above, this matter again on 8th of January 2025.
Lordship,
Item 18 and connected item 85.
It pleases my lord.
What is this?
This pertains to non-payment of compensation for the dwelling house of the petitioner, my lord. My
What
lord,
is this IA for?
the IA for, my lords, there was an interim order passed that during the pendency of the writ petition, the dwelling house of the petitioner should not be destroyed. But in the meantime, my lord, notwithstanding the fact that the orders were shown to the officials, they came with my lords, excavators and demolished the gate of the petitioner, my lords, along with the garden and everything.
And
I have appended pictures also, my lords.
Thank you, Your Lordship. Lordship, Mr. Seaborrow is unwell today, so he could not attend the court. On his,
Here the
you can't do like this. Such actions is not permissible. Respect to widening of the roads. This is not in area. This is for widening of the roads.
47.
In that the latest judgment of Justice Adiwala, in that
Not Nagaraju.
what?
Nagaraju.
No. Another judgment is there. 3 judges, Justice D.Y. Chandrachud, Justice Padiwala, and there's, I think, Justice Mishra. 3 judges. 2 days before, in demolition case. So I think he passed the judgment on 7th of November.
Get hold of it. Here the issue basically is, my lord, what had happened, my lord. Initially, 11 lechas of land was acquired from the total 3 kathas of land of the petitioner, my lord. Now, after the earthwork had started taking shape, my lord, the petitioner had doubted that that 11 lectures of the land which has been acquired would also encompass her dwelling house, my lords. And therefore, my lords, the petitioner had made representations to the Kala as well as the other authorities. My lords. So pursuant thereto, my lords, the Kala had requested the circle officer to conduct a joint survey, my lords, to see whether the 11 lectures would encompass the dwelling house. My lords. Now, pursuant to the joint survey, my lords, what had happened, the circle officer had furnished a report saying that yes, the land has been acquired, but now since the alignment is in shape, we don't require 11 lectures of land, we only require 7 lectures of land. Now, if that 7 lectures of land is acquired, the right of way,
Has the 3D notification come?
3G notification has been come, my lord.
3D come.
3D come, the land has vested upon the central government. Now, the only issue is, my lords, once the land vests on the central government, can they reconvey or reassign it, my lords? They have already acquired the land. Now they are saying we don't require 11 lectures, we just need 7 lectures. And if those 7 lectures is acquired, my lords, the right of way is at the edge of the house of the petitioner, my lords. Now, 11 lectures naturally would encompass the house, but they are saying now we don't require 11 lectures. We have paid money for 11 lectures, but we now require only 7 lectures. Now, there are judgments of the Supreme Court, my lords, which says once the acquisition proceedings are complete, my lords, or because it's an acquisition proceeding under the National Highways Act, my lords, and my lord is aware for vesting, possession is not necessary. Section 3D2 is enough to vest the land upon the central government. Now, the Supreme Court has clearly held, my lord, once the land is vested upon the government, even if it is unutilized, that cannot be reconveyed or reassigned to the original owner. So, my lord, I'm entitled to the compensation of the house dwelling house, my lord. And it was under such circumstances, my lord, the interim order was passed.
What?
Interim order was passed that you carry on with the widening of the road, but you should not destroy or demolish the dwelling house. Now, the order.
The dwelling house is a part of the 11 lectures.
Dwelling house is part of the 11 lectures.
So, what is the
Well-
interim order is nothing to do. We get the compensation.
No, my lord, I'm still residing, my lord, till the time it is not decided. Because the order, my
There's
lord,
nothing to be decided.
because
First of all, there could not have been an interim order. Anyway, that is an interim order. We finally dismiss your petition.
because dwelling house, in all due respect.
You
also-
will be entitled to the compensation. If they give less compensation, you have applied, go under 3G5.
No, my lord,
Respect,
I
my
would have approached the arbitrator. I would have approached the arbitrator if there would have been some, my lord, disagreement with regard to the quantum of compensation. Now they are saying that we won't even pay compensation, we are not taking your house. Although it is vested upon the central government, the land upon which the house is situated, but they are now saying, no, we just require 7 lectures. So only 7 lectures of land would be,
No, you will be entitled to 11 lectures. There's no quarrel with that.
there has to be an order to that effect, my lord.
Why?
Because there's the order which I have impugned, the circle officer clearly states, my lords, that we don't require 7 lectures, so we're not paying compensation for the house. We only
No,
require
they
7
they
lectures.
cannot say.
In this respect, my lord, we have filed affidavit in the main petition, my lord. Inter alia stated that though that 3G notification has come, but specific stand is taken by the competent authority regarding the respective tag, my lord, that there is no 3A and 3D. In last order, my lord, 9/6 of 2023.
No 3A.
No 3A, but
The
3C,
entire acquisition goes.
then the compensation was given on the.
No, without 3A, nothing happens.
That is revealed from the record. It is admitted by the respondent.
And then why did you demolish?
Then in further also that 11 lectures land, he has got compensation about to 5,56,160 million.
They have paid compensation for the 11
That is
lectures.
the
Now
basic
they are saying, my lords,
percent.
that.
0.6.
So they have already paid the compensation.
Yes,
Yes,
that is admitted by them, my lord.
But now,
It has, as per our stand, my lord, that it would have been issued, but so far as 3G is concerned, it is prima facie, it is already, my lord, notified, but there is no 3 and 3B. That is the factual position right now.
means all the mistake being done by the central government.
That extent my friend.
No, not by them, central government.
Yes, madam, that he is representing,
Who is representing?
he is representing.
He is only appearing for national highway. He is appearing. You are appearing for central government. How did this happen? Because the notification is issued by MOT, not by national highway. For the benefit of national highway, you issue that. Why did you issue it? Without 3A, how could you do that? And that has come out on affidavit.
Verification, it is,
But the entire acquisition process is gone. And possession taken.
No, my lord, they have demolished, my lords, the gate and everything. 7 lechas they'll take up, my lords. The other
You have already been paid the compensation for 11 lechas.
11 lechas.
Then
Yes.
what gate you have?
No.
No right for any gate.
No, that is not the issue, my lord. Lordship, everything will be clarified by the letter of the Kala itself, my lord.
on.
Page
the
36 for a
verification,
moment, my lord. I need to take a
Representation.
page 36.
Yes.
Page 36, this is the letter by the Kala addressed to the General Manager NHIDCL, Annexure I of the writ petition. Manager. Sir, with reference to the subject cited above, I am forwarding here with a complaint petition received from Srimati Deepa Gogoi, who is the petitioner, my lords, wife of Lieutenant so-and-so with regard to the matter of disbursement of the structured dwelling house. It is to inform you that as per 3G approved list, the area notified for 4-laning of NH 37 from the plot of land situated at Khatwal Gaon bearing so-and-so was 0.014 hectares, bracket approximately 11 lessas. And accordingly, the compensation for the said area of land amounting to such and such only has been duly released to the petitioner. But recently, in the joint verification report by letter dated so-and-so, submitted by the circle officer, Amguri Revenue Circle, it reflects that only 0.009 hectares, approximately 7 lessas of land, comes under the purview of the alignment of 4-laning of NH 37, considering 80 feet as per the alignment chart of the NHIDCL officials from the center of the existing road to the said plot of land belonging to the petitioner Pattada Srimati Deepa Gogoi. And if so, then the dwelling house of the petitioner does not come within the alignment of 4-laning. If it is 7 lessas, well, the dwelling house does not come. The petitioner has objected to the fact and claims that they were already paid compensation value for the 11 lessas of land area as acquired by the 4-laning of NH 37, under which the structured dwelling house of the petitioner comes within the alignment for acquisition, and accordingly they are entitled for compensation for the entire structured house. The petitioner also claims that if 0.009 hectares, approximately 7 lessas of land, as per the recent joint verification is to be considered for acquisition, even then they are entitled for the compensation of the structure, considering the security and safety concern and of their life and property, as the dwelling house of the petitioner is at the very edge of the boundary of the land acquired for the 4-laning of NH 37. And in support, they have cited so-and-so, so-and-so, so-and-so.
So
Now
you have
the
filed this writ petition on the basis, this basis?
Malad,
You have filed the writ petition on this letter?
not this letter, we have impugned, my lord, inter alia, the report of the circle officer.
No. On this letter. What because of action here? 3G has already been done.
Yes.
3D. So the land vests upon the state.
Yes,
So under such circumstances, the question does not arise from going back.
exactly.
And what stand you are taking has a far-reaching consequences. Are you aware? And this is not one land. The entire thing will go for these 4 lessers. Are you aware what stand you are taking? Isn't it the most irresponsible statement of the Kala? No, madam. Isn't it irresponsible?
Yes, but what record reveals is,
If it is so, then how do you take care of it? You did not go under 3A. No, the petitioner hearing is not objecting it. Petitioner is not objecting to the 3C, 3B or 3C. Not objecting. He's not objecting even to the 3D. Now, in order to save for 4 lesser, or payment for the house, you are coming up with this. Why is the central government not taking action against this type of kala of authorities? This type of letters are serious letters. In fact, the NHAI DCL should come before the court and come up with these type of letters.
That has been their stand, my lord. They say.
And when the land has been taken, it will be demolished. We have no business. We vacate the interim order.
Yes, in that case, Lordship may observe that I am entitled for the payment of compensation for the dwelling house. That's the prayer, my lord. My lord, may kindly take up the affidavit by the NHIDC just for a moment.
No. If it is, you are entitled, you file it. Why should we say anything to that effect? Tell me.
Because, my lord, they are saying now that we don't require 11 letters.
They don't require.
That's
the
why we're not
deputy,
paying
But
compensation.
can you override that? That I will obviously say. I will obviously say once 3D has come in, the land bests. So under such circumstances, the petitioner would not only be entitled to the house, to all the compensation in terms of 3G7. That's all.
Yes.
That's it. What
Yes,
else?
that is
Why
fair.
these interim orders and all? Impeding the progress of the nation by in hand in glove with Kala. Petitioner in hand in glove with Kala.
No, my lord, my lord, see my pleadings, my lord. I'm a widow. I used to reside in Bombay, my lord. My husband was a junior commissioned officer in the army. And only when the 3G was, my lord, they paid money, my lord. I've never objected to the 3G. I'm not even objecting to the land, my lord. You take away my 11 letters. But you give me compensation for the dwelling house.
They will pay.
Yes, my lord, that is my.
Now they have you made that 3G has already been made.
Yes.
So you have to go to the arbitrator. There's no way out.
Okay, only then, my lord, they have to now, they cannot reassess.
No,
That's my.
Mr. Mohanta, kindly appreciate one thing. The biggest problem which happens when we pass orders saying that you are entitled to this and ask the competent authority. See the problem which happens. There are many cases which I find later on when it comes before us, what the problem happens. There are many orders being passed by this court with due respect to the effect that the deputy commissioner is directed after the award is being passed to recompute in terms with a new act or take into consideration these and all. Award is there. Award has become final. Once the award is being final, how will he do so? Tell me. He loses his jurisdiction. Can I give a jurisdiction to him? Because when an award is passed in right to fair compensation or the old act or here also, it is final in so far as Kala is concerned. Final in so far as the collector is concerned. The only way you can change it is by the reference court. And the problem, there are many cases which I find. That day I found a case out there. What happened? The court directed that the petitioner herein is entitled as per the 2013 Act. And as such, directed the collector to pay. Now, what the collector does, he sends an estimate to the government that this is the estimate we have to pay now. Now, the government says, okay, sits on it. The petitioner comes and files a contempt that there was a direction to do within 6 months. Why they have not done? I have not got the money. Now, tell me, can I hold the revenue secretary? No, because of the fact the collector has not passed an award. Collector has to pass an award, then only he has to approve. Without an approval, how does the payment come? And if the payment doesn't come, how do you catch hold of the finance? These are the biggest problems which happen. I may very well direct, but tomorrow, what will happen? The competent authority, he cannot do anything. He has to again pass another 3G, which will require an estimate to be prepared. And on the basis of the estimate, it will be sent to the National Highway Authority or anybody, and then they will approve and then make the payment. But all is a very big problem because this court can't direct the NHIDCL to make the payment.
to the color. In fact, the same thing had transpired, my lords. There's a judgment of this honorable court where the Kala, same district, my lords, Shibohagar, my lords, wherein, my lords, the assessments were prepared, 3G was prepared. Thereafter, on his own, he reassessed and reassessed the compensation amount, my lords. Then the honorable court held, my lords, that the power of review or reassessment is not there under the National Highways Act.
Cannot do
be done.
anything. And in fact, after the 3C he has passed, he's functions officio.
Functions officio, exactly.
What type of these letters are issued? Huh, madam?
This
What type of
judgment
letters your person is issuing? Doesn't he know anything? Additional Deputy Commissioner? Ipsagar, he must be very sad because you have not used the word District Commissioner or Co-District Commissioner now.
The district commissioner. And my lords, if my lords kindly
And
takes up,
because of that, the matter is pending from 2013. What is this?
well, this is the judgment where the Supreme Court has held, my lords, one, the land vests on the authority, it cannot be reassessed or it cannot be reassigned, my lords. And yes. And another just the
Mr.
ground, my
Moko,
lord.
I think I know that.
Yes, I'm so sorry, my lord. Well, if my lords kindly takes up the affidavit in opposition, just to point out just one thing. But yes, my lords, in the affidavit in opposition, the NHIDCL had attended a trace map, my lords. In the trace map, they have shown that they don't require 11 lectures now, they require 7 lectures. If the 7 lectures of land is acquired, my lords, where does the building situated, my lords? It's at the edge of the ROW. And in my affidavit in reply, I have also attended that letter by the NHIDCL General Manager himself, wherein he states, but that's my alternate argument, that's why I'm just making that point, my lord, wherein he states, my lord, all buildings situated at the edge of ROW would also be compensated because it is bound to get damaged. So even otherwise, even assuming that they have the power.
No, that
just
doesn't
point-
happen.
Yes.
But how do I dispose it of? He doesn't know anything. You don't know anything. You know anything?
Well, his senior had called my lords today. He had called my.
has to be here.
In that case, my lord would, it has part heard, my lord. After 2 weeks also, my lord.
By the, heard Mr. P. By the instant petition, the petitioner have assailed the order dated 16/7/2019. The communication dated 16/7/2019 as well as the report of the circle officer. This court had posed the question upon Miss M. Bormon, the learned counsel appearing on behalf of Kala, as to under what authority such a communication is being issued after the determination of compensation made by Kala in terms with section 3G1 of the National Highways Act 1956. So in addition to that, whether this court had put a query upon Ms. Bormon as to whether such communications are permissible in view of section 3D of the Act of 1956, which specifically mandates that upon issuance of the notification under the said provision, the land vests upon the central government. Ms. Bormon, the additional deputy commissioner, Ms. Bormon shall obtain instruction this matter again on 17/12/2024 at 2 p.m.
Some protection, my lord, demolish
What
my house,
protection?
my dwelling house, my lord.
Thing is happening.
I'm staying there, my lord.
You on one hand won there.
But till
That is done in 2019. We are in 2024. 5 years have gone. These matters require an urgent conclusion. But I am not here. Otherwise, I would have finished it on
17, my
Monday.
lord, 17. I'm very grateful, my lord.
So many, I couldn't give it. The problem is, however, I've given you the leave to go to the civil court, produce whatever it is. The problem which happens is taking into account so there are disputed questions of facts. The fact that you have stated that you have collected from the revenue village, and they categorically say that the amount you have collected that is not commensurate with the availability of barks in the revenue village. These are reports. So there their problem arises. So you have to go to the civil courts.
Only my lord, 2013 to 2024, my lord.
I have said further the period of pendency of the writ petition, that is from 7/12/2013 till the date of the judgment, be excluded while computing the period of limitation. Because there were certain bans. The bans that have happened in 2003. No, not 2003, 2000. From 2000, there was a complete ban in removal of any barks from the
From
forest.
the forest, my lord.
Forest.
Forest area.
So therefore, the question is whether it was from the forest or not are disputed with their reports. Now, just for example, if it was from the forest and without a clarity, therefore I said here, no, you see, kindly see here. In the backdrop of the above, the pivotal question which arises is whether the barks in questions collected by the petitioner and seized by the respondents were collected from the revenue village or the Manas Reserve Forest. The materials on report show a complete divergent stand between the parties. Additionally, if the barks were collected from the reserve forest, not only the same amounts to a forest offense, but also came within the complete prohibition mandated by the orders of the Supreme Court referred to herein above, as well as the communications issued by the central government and the state government. Under such circumstances, without there being a clear picture on the legality of the barks collected by the petitioner, the question of imposing damages upon the respondents on account of commission of a constitutional tort in the present facts on the basis of the materials on record do not arise. Is why I say. And before parting, this court observes that the dismissal of the writ petition shall not preclude the petitioner to avail remedies before the competent civil court. Further, the period. That is why it took a long time. Something somewhere, because the subsequent orders which were passed by the Supreme Court said about only reserve. Initially, the order which was passed in 1998 only categorically stated about all. It was absolute. Then in 2002, there was a bit relaxation to that extent that only forest, sanctuary and all these things were mentioned.
Item 81, fixed at 2 p.m.
Yes. The child is with whom? The child is with whom? With the mother.
Child is my adopted. They are from adopted parent.
No. The child is with whom now?
At Matrimony CWC. Children Welfare Committee.
Here the mother wants to give the child in adoption. You want it. Then why don't you follow the procedure?
My lordship.
Why don't you follow the procedure?
They are ready to obey.
No, there is a procedure for adoption. What is the procedure for adoption?
Consider adoption regulation as per adoption regulation matter 2022. We have explained in the activity. Is my lord 40, my lord.
Okay.
Is 40.
Where is paragraph rules 6 and 7, where's the procedure?
No,
Give it to me. So now the child is with you.
Yes.
Now, if the mother is traceable, biological parent is there, then what happens?
That case, my lord, their consent is also
Huh?
required. In that case, their consent will be.
The consent is here, there. Now, what is the procedure?
Then
What is the procedure for a year? The Indian perspective adopted, if interested to adopt an orphan or abandon or a child orphan, may apply to the same on the designated portal by filling up an application as provided in Schedule 6. Now, did you file that application? No.
actually, on 11
And then you
January.
do one thing. You file the application. You file the application as per Schedule 6. We take up the matter after 1 month. As now she is in the this thing, and she needs to execute a deed of surrender. Then
Before,
If my lord, biological mother exists.
execute a deed of surrender.
before my.
That is what. And then you see to it that the mother signs a deed of surrender and submits to the CWC. And after that, you also file an application. Let me have this matter again on
In which port, my lord?
22nd of January.
The portal.
That-
In the portal.
Portal, my lordship, if we apply a file in before through portal, my lordship, then we will not get such child, my lordship.
Huh?
If we online apply online, then we will lose my baby, my lordship.
No, no. You will file the portal
Yes, my lordship.
and provide the number to him.
Ah.
He will see to it. Don't worry with this. No, because the procedure has to be followed. So let this be first done. Let him, let the deed of surrender also be there, and you submit your application by portal and you will be given a number. And that number you intimate to him, this council. He will intimate to the CWC and the CWC then come back to me.
Yes, my lordship.
Let
No.
us see by this way.
Yes, my lordship.
Because after all, you are taking care of the child. We don't want this to be in this. The issue involved in the instant case pertains to a child pertains to a baby namely Uday Sharkar, who was born on 28/4/2023. Admittedly, the respondent number 7 is a single mother. You were also a rape victim.
Yes.
Admittedly, the respondent number 7 is the mother, is the biological mother of this child. And she was a victim and she is an unmarried girl. Woman, married. What is your age? Age of the respondent number 7? Somewhere here. These type of affidavits without age. Admittedly, she was a victim of rape. The petitioners herein are issueless. You are issueless? No baby? Do you have children? Are issueless and wants to adopt the child, the infant, Master Uday Sharkar. However, it is seen that it is also seen from the records that presently the child is under the custody of the Child Welfare Committee. This court, upon giving an anxious consideration to the matter and taking into account the affidavit filed by the respondents as well as the Adoption Regulations 2022, is of the opinion that if the petitioners want to adopt the infant baby, the same can only be done by following the mandate of the said regulations. However, it is seen from a perusal of Regulation 7(3)(7) that the parent who wishes to surrender the child under subsection 1 of section 35 of the Juvenile Justice (Care and Protection of Children) Act 2015 is to execute a deed of surrender It is also seen from a perusal of Regulation 10. Regulation 10 as to the manner in which an application can be filed, has to be filed for the purpose of adoption by resident Indians. In the instant case, the respondent number 7 have not till date issued, executed the deed of surrender, nor the petitioners had submitted any application in terms with the regulations. Accordingly, this court grants liberty to the petitioner as well as the respondent number 7. And grants liberty to the respondent number 7 to submit a deed of surrender before the Child Welfare Committee. The petitioner is also given the liberty to submit an online application form as provided in Schedule 6 of the regulation in the designated portal. Mr. So-and-so appearing on behalf of the social welfare.
Yes, respond number 1 to 3.
Respond number
1 to 3.
1, 2, and 3. This court further observes that upon filing of the say, Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 submits that upon filing an application in terms with Regulation 10, a number,
This is number.
a serial number would be provided to the applicants. Taking into account the above, this court fixes the matter again on 22nd of January 2025. In the meantime, the respondent number 7 as well as the petitioners are given the liberty as above mentioned. The petitioner further shall, upon the counsel for the petitioner, further upon receipt of the application number, shall provide it to Mr. So-and-so, the counsel representing the respondent number 7.
1 to 3.
Oh, respondent number 1, 2, and 3. Who shall duly intimate the Child Welfare Committee about the application so filed by the petitioners, and that about the pendency of the writ petition. Full stop. On the next day, an update may be given as regards the further proceedings, further process being followed pursuant to such application being filed. We'll see to it. It will be done. Don't worry. Matter be reserved, shown as parted.
Item 19.
This case, Lordship, I am praying for under 7 days and to file a
Mr. Sharma, H. Sharma pays for 7 days' time in the matter for which the matter stands adjourned.
As per instruction, my lord, amount has been paid, my lord.
It has been submitted that the matter has been, that the petitioner have been duly released the amount of rupees, how much?
Total amount, my lord, 31 lakh 19,000 0
31 lakhs 94,
19,000 and 44 rupees.
31 lakhs 19,044 and 044.
04.
In respect to the amount entitled to the petitioner. Full stop. In that regard, he has produced an instruction. Mr. So-and-so, the counsel appearing on behalf of the respondents have produced an instruction which is kept on record and marked with the letter X. Taking into account the above, the instant petition therefore stands closed. The remaining amount is the TDS.
22.
In this case, lordship, a direction was given to us, there is no bar in demarcation, lordship, but they shall not be evicted.
Huh?
There is no bar in demarcation of their land, but they shall not be evicted on the basis of that demarcation. That order was there, lordship, and we have been directed to obtain that instructions, lordship. We have not yet received the instructions. May I please-
You have not received any instructions. Taking into account the
Order
Mr. A.
dated
Sharma submits that the instructions
11/9.
were submitted. Yeah, the instructions were sought for on 11/9/2024. It has not arrived. Accordingly, it's the matter of a few weeks. In the meantime, the interim order passed earlier shall continue.
23.
I am appearing for response number 4 and 5. I need some time to file application.
Appearing on behalf of the respondent number M. Sharma.
Fine.
Appearing on behalf of the respondent number 4 and 5, 4 weeks time to file affidavit. This is the matter after 6 weeks.
Acknowledged.
24.
May I please, your lordship? The direction of officer of court to place
Yes, what do you have to say,
by the
Panchayat?
PNRD department.
None appears on behalf of the PNRD on call. List the matter after 3 weeks.
26.
Obliged.
Yes, what is your stand? You file your affidavit?
Secretary Lordship will file by next week.
Is so-and-so appearing on behalf of the
Lordship. District administration.
district administration submits that 2 weeks time will be granted for filing the affidavit. List the matter of the matter of the 4 weeks.
27.
Yes, Mr. Lordship. Our instruction is awaited and some more accommodation is required, Lordship, to obtain the instruction.
Huh?
Some more time is required, Lordship, to obtain the instruction.
Instructions were sought for by the order dated 3/10/2024 have not arrived, have not been placed. It's the matter of the 4 weeks. In the meantime, the instructions be placed.
28.
May I please, your Lordship, matter is laid by Sujan Chaudhary. He is on legs in court number 2.
Who?
Lordship, kindly pass over the matter for time being, Lordship.
No passover for the time being. Who is it?
This matter is laid by Sujan Chaudhary. He is on legs in court number 2.
Counsel appearing on behalf of the petitioner seeks for an accommodation taking into account that the senior counsel is not available. List the matter for 4 weeks.
29.
The same case.
I'm led by Mr. K. N. Chaudhary, who's on legs at the moment.
Here also. Has been submitted by the learned counsel for the petitioner that the senior counsel is not available. This is the matter of the 6 weeks.
30,
Actually, today we have filed our affidavit.
The file
Yes, Your Honor.
has been submitted, that the affidavit has been filed by the respondents. First of all, taking into account the liberty is given to the petitioner to file a reply if so advised. List the matter after 6 weeks.
Right.
32 and 33.
Your lordship. I am respondent number 6 in 32 and petitioner in 33, lordship.
Hmm.
Lordship, in item number 32, lordship, they are asking for allotment of land, lordship, which we are possessing, lordship.
None appears on behalf of the petitioner on call. When the matter is read for the end of justice, matter stands adjourned to be listed after 6 weeks.
Lordship, I am suffering, lordship, can I sort it?
Can't help it. If I take up these matters, there are problems of other councils.
35,
Apply.
None appears on behalf of the parties, matter be adjourned to be listed after 8 weeks.
37,
None appears on behalf of the petitioner, this matter after 8 weeks.
38,
May I please, Your Lordship? Lordship, of the matter relates to non-payment of dues by the PHE department, which is admitted. On the last day, they're taking time to obtain instruction.
None appears on behalf of the PHE department, for the end of justice, matter stands adjourned to be listed after 8 weeks.
39,
Same,
Your Lordship, similar matter.
8 weeks, same order, huh?
Lordship, 40 is also similar. 40 is also similar, Your Lordship. 40 is also similar, Your Lordship.
41,
Yes, instructions? 41?
Not receive any instruction, Your Lordship.
No instructions are received as submitted by the counsel for the petitioner, for the respondent, none appears on behalf of the petitioner. This is the matter of 10 weeks. In the meantime, the respondents are directed to bring on record their stand.
42,
Same, man.
10 weeks.
43,
Lordship, it is similar to the, Lordship, yesterday has reserved for judgment, cancellation of GST registration. Lordship, yesterday, Lordship has reserved.
Counsel appearing on behalf of the Finance and Taxation Department seeks for some accommodation. This is the matter of the 10 weeks.
Okay.
In the meantime, the Finance and Taxation Department.
Excuse me, I'm sitting here, my lord.
75.
35, I was sitting, my lord. Somehow it is there.
Nobody appeared, so
35 item.
35, okay? 35 key order,
35, my lord.
list of the 8 weeks. Put your name, give your name out there.
PP does.
Keep it us. Yes, madam. None appears on behalf of the petitioner as well as as for the secondary education department. List the matter for 4 weeks.
76,
Here, my lord, I'm sorry, my lord. I just, item 75, Lordship has just
It clearly said it. I had it after 4 weeks or something.
Proposal
Yes,
has
what is
been
it? Oh, this.
Yes.
Now it has been submitted to whom? To litigation. Yes, when are you going to take up this issue?
As per the final instruction, Lordship, they have received the proposal, working on it, Lordship.
You have received the proposal. Is so and so appearing on behalf of the school education. Department of School Education submits that a proposal dated 26/11/2024 has been received by the said department. It has been further submitted that the same is being worked into and shall provide an update after 2 weeks. This matter again on 17th of December 2024, on which date an update may be provided as regards the pension proposal of the petitioner. This court further keeps on record the instructions so placed by Mr. B. Chaudhary appearing on behalf of the BTC. And marks it with the letter M. Madam, we kindly ask these people to do it. Well, after all, she's not getting any amount because of her husband. The son was what you call,
Lordship.
the son was a school teacher. And you are also not paying the pension also. And when will she get? I hope by the time I finish up this matter, I mean, the petition is disposed of. She's alive. Some
77,
humanity must be there with your officer.
Lordship, I'm appearing on behalf of Mr. A. Kabul.
Affidavit filed. None appears on behalf of the corporation department on call. In addition to that, no affidavit has been filed pursuant to the order passed by this court on 6/11/2024.
Lordship, I pray for an interim hearing.
Want an interim?
Interim hearing, Lordship. Lordship, I pray for an interim hearing, Lordship.
What is that interim hearing?
Uh,
You want an interim order?
yes, Lordship.
Okay, we state then. What do you want?
Before vacation, Lordship, on
Huh?
before vacation on any date of
What
December.
do you want? What is the name of the association?
Lordship, MS Arya Electors India Private Limited.
Huh?
Arya Electors India Private Limited. Arya Electors.
No. What are you asking?
Lordship, I pray for him, hearing, Lordship. My senior, he could not come. He had an accident and he was discharged yesterday. Lordship, my senior, he could not come. So I'm appearing on behalf of my senior, Mr. A. Kakoti. So he instructed me so that I could pray for an interim hearing, Lordship.
Okay, tell me. Again,
Interim hearing on next day, Lordship.
what is this interim hearing?
By my senior.
Huh? More alketa matter আছে? Neither. He has not filed his affidavit. So I allow your petition.
No, my lord, I will place this instruction.
No.
No, I have, Lordship will see, my lord. I have prepared the, my lord, affidavit.
I'm not concerned. You have not filed. Go and file appeal.
No, Lordship will kindly record it, my lord. that
No,
I have received.
absolutely no, mister.
I have received
No,
instruction, my
Mr.
lord.
Talukdar.
They
Absolutely.
have not provided me, my lord.
What they have not
The
provided.
department has not provided me the.
So what? I'm not concerned.
So Lordship
We
will record
passed the
it, my-
order, set aside this order.
Lordship will record it, my lord.
No, nothing doing.
Not as I, my lord, my prayer is. My lord, I intended to file, but in absence of the instruction, I could not file. Lordship will record that much, my lord. I have no objection.
The members of the society will avoid the
That my affidavit is also ready, my lord. I have prepared it.
concern. Yes, what is your case?
This is against the construction company, Lordship. MS Arya Erectors India Private Limited.
And?
Lordship, the case is related the election of the cooperative society.
So your case is 37C and 43.
Yes, Lordship.
Means they have a pecuniary interest. And as such, with the society. And as such, they cannot hold the position of a board of directors. Now, what is the pecuniary interest?
Lordship.
Do you know or don't know?
I have studied the case, Lordship.
Fantastic. Tell me, what is the pecuniary interest?
Lordship, my senior, he wants to do the hearing, Lordship.
Then, where is he?
Lordship, he was at the hospital. He was discharged yesterday. He had an accident.
Counsel appearing on behalf of the petitioner is not aware with the matter upon matter, taking into account the matter stands adjourned to be listed of the 8 weeks.
78.
It pleases your lordship, my lord. My lord, here the government has also filed affidavit, my lord. And therefore, my lord, they also say that our complaint shall be, my lord, considered. Complaint is page 49 against respondent number 6, my lord. By violating the permission, my case was that, my lord, they have, my lord, raised construction, and this complaint is unattended, my lord. Some direction may be issued to the municipal board, my lord, Karimganj Municipal Board, my lord.
Why?
To, my lord, after affording both the parties, my lord. Respondent number 2, district, my lord.
You filed your affidavit?
Yes.
Reply?
My lord, in fact, there are cross cases between the private respondents, and yesterday, 2 orders has been passed. It's private respondent here, he also have filed a writ petition before this court, and review petition was also preferred by the private respondent here, the father of the petitioner here, and all the disputes have been referred to the Karimganj Municipal Board to resolve the issues, or by 16th of December, they will appear, and within 45 days, the dispute should be resolved. So similar, here also they have a cross of case before against the private respondent. These also be taken up together. That is my instruction. Because the father of the petitioner here, he lost a complaint, the petitioner here has lost a complaint against the private respondent, and the private respondent also lost a complaint against the father of the petitioner here.
We direct this matter to be listed before Justice Surana.
You can dispose of it.
Why?
Because yesterday 2 matters, the first writ petition was disposed of by my Lord Justice Soumitra Saikia, directing the municipality board to dispose of within 45 days. That submission was made before the my Lord Justice Surana. My Lord Justice Surana in review petition has passed this order. Although we have not got the order of my Lord Justice Soumitra Saikia, and a similar line, this must be.
Let it be listed. He's taking a bench 5. This is a bench 5 matter, I suppose. It has been submitted by Mr. Edhor. The similar matter has already been dealt with by a coordinate bench by Honorable Mr. Justice S. Sarkia, wherein specific directions have been passed. It submits that the said order is, however, presently not available. So list the registry shall accordingly list the matter before Honorable Justice Swains.
Kindly be on Monday. Because it is already directed 15th of, because other meter they already forwarded before the municipal corporation.
Absolutely no.
Applies.
Item 82.
Affidavit filed?
Yes, my
Then reply file?
Okay.
You want to file reply?
No.
Okay.
But actually, in affidavit, they have said what 44 lakhs has been decided by the deputy commissioner, my lord. That Grid Corporation, they filed an affidavit, they say that they filed a review petition. General manager of the district. But one thing, my lord, how that 44 lakhs decided, my lord, that detailed record is not produced. It
Not
is
produced?
not produced.
Who decided?
It is stated that on the basis of Monroe report, my lord, that has been decided.
by the deputy commissioner. But how this breakup has come, my lord, that is not given. And it is mentioned that this Fair Compensation Act has been applied.
No, the district commissioner here have assessed it subsequently after the initial assessment.
What happened in this matter, he has filed a representation regarding enhancement of his.
Can the district commissioner do it?
It is only a request where he has made a assessment only. It is only to the part of assessment. We are only, he has made an assessment, my lord, as per 2013 Act, but land acquisition was not there, my lord.
Understood. First
yes.
of all, how do you, no, first of all, there is already a Jirat compensation given. So there is already an order being
He-
passed under the relevant provisions.
Statement in page 40, my lord, para 8. Further in view of above, page 40. Second part, he has stated, my lord, that no jurisdiction, that prevailing notification under.
Response number 6, na?
Yes, my
Para?
para 8, page 40, my lord, second paragraph, he has stated. The guideline of the central government has been prevailing. Only a request letter or his representation regarding, as he want to know about the reassessment. Assessment, my lord.
So in view of this, your entire case is on 17/8/2022.
There was a joint meeting with the grid officers and the deputy commissioner. And in the meeting, it was decided that low compensation has been given. So to avoid obstruction from public, that should be reasonably given.
So
On that
therefore,
basis,
don't you
my lord,
think
this-
that aspect can be better taken up by the district judge? That is as per the provisions,
But the,
not this court.
but the deputy commissioner, after that meeting, my lord, it has been done. And now what happened, my lord? The grid corporation filed petition for review of that 44 lakhs. That has been stipulated.
They may
in the
file, but can they file it? Is it necessary for them to file?
Review file.
Lordship attention to paragraph 11 of the petition, my lord, page 8. ma'am. The respondent number 3 also paid an amount of rupees 1,02,230 against the Jirat standing on the schedule and rupees 21,95,522 against value of the house, which also received by the.
Who made the assessment for this payment?
He has already admitted, but this amount was paid, my lord.
You pay the amount on the basis of some assessment being made. Who made it?
The district authority, my lord.
So when the district authority have already
My
done,
lord.
how can the district authority again do it? That is the question out here. So therefore the question is,
By the.
if the petitioner is aggrieved,
He
he has to go under 10H, na? 10H or 16H?
No, my lord. The statutory remedy my lord, under section 16(3), my lord. But it will go back, my lord. He
16.3. That is it.
So your lordship, regarding page 8, my lord, what is referred by my learned senior, my lord, it is rupees 1,02,230 against Zirat standing on the schedule land, and rupees 2195 against value of house, not regarding land.
Mr. Sheikh, I think I have not been able to convey it to you, or what you are saying is beyond my comprehension. Let the matter be listed next week before a judge who can understand your arguments and they can answer. List the matter next week.
Next week. Next week. Awesome.
83.
None appeared. Yes. State. What is your instructions in this? Who is appearing? Why is this Gorsuk police station parking the vehicle in his car, in his vehicle, in his land?
We have received an impact from Madam.
Show me. Now there is no vehicle.
Yes, yes, your lordship.
Vehicles have been removed.
Yes.
Pursuant to the notice issued by this court on 22/11/2024, instructions have been placed by the counsel appearing on behalf of the state respondent of the Deputy Commissioner of Police Crime dated 26/11/2024, wherein it has been categorically mentioned that though certain 10 vehicles were, the damaged vehicles were lying at the plot of the land of the petitioner, but the same was removed pursuant to receipt of the said notice. The said instruction is kept on record and marked with the letter X. The learned counsel for appearing on behalf of the petitioner also submits that during that pursuant to issuance of the notice by this court, the vehicles in questions have been removed, and as such, nothing further remains in the petition. Accordingly, the petition stands closed. See, you got the relief. You got the relief, but not the 10 lakhs. Next.
Okay, hopeless.
For orders, item 44, part hard.
Finally, amount has been paid. It has been deposited for the treasury. 1,78,000.
It's been deposited.
For the treasury, there's some minor problem with the account of the petitioner. So my lord, in fact, the district authorities are working on it. Even they visit the bank and all. Lord, will kindly keep a copy of this.
We have a senior. I'm apologizing, she could not appear before this court today. I don't think amount that we have received is till the month of August on.
And then, my lord, we have now it continue.
The requirement for making payments for
caretaker has not been given to us.
Huh?
The amount required for appointing a caretaker has not been paid to us like till now.
The direction was to pay 1 lakh immediately within 30 days. And thereafter, say, the stipend, a monthly stipend equal to that of a skilled labor, whatever is notified amount, that is to be paid. So, we have now paid from January, last week's order was of December 23. From January to August, we have already deposited it before the treasury, some 78,000 at the rate of 9,800, whatever is available as on date. And regarding the caretaker, we have.
No, kindly give it on what you have done
Yeah.
on detail.
Yes, I will file that for that.
Let us have it on 18th.
Sure.
You give a detail.
Yes,
Huh?
yes, I will file that.
Mr. P. Gogoi, the learned counsel appearing on behalf of the petitioner had submitted that an amount of rupees 1,78,404 have already been sanctioned, and the said amount is in the process of being disbursed to the account of the petitioner. However, on account of some technical problems, the said amount has not gone through, for which the departmental authorities in is in talks with the petitioner. Full stop. In this regard, full stop. The counsel appearing on behalf of the petitioner submits that some certain amounts, the regular stipend which was directed by this court have not yet been paid. Mr. B. Gogoi had submitted that till the month of August 2024, the entire amount of stipend is included in the amount, in this amount.
Yes, yes. 1 lakh.
In the amount of, I directed 1 lakh, na?
1 lakh immediately thereafter,
And the further process is on. Full stop. This aspect be brought on record by filing an affidavit by the respondent. The certain documents so submitted are collectively kept on record and marked with the letter E.
So one more line of it, the petitioner will inform us who will be the guardian, that he has not informed. We cannot give the 3,000 without he first appointing a guardian, caretaker. We'll have to appoint a caretaker, then on that 3,700 will be paid. So that we have sought for some information from him. That he will place before his honorable court, who will be appointed as a caretaker. Then we will release it back.
And the mother of
Only
the
on
petitioner would be the appropriate person.
Guardian cannot be a caretaker.
You see, in every case, I'm not saying about the petitioner out there, in our cases also, you have to give the name of that person who would be the beneficiary, and the amount directly goes to that account. Everywhere, this is the practice. Let's accordingly. On 17, huh? 18, 18.
Item 46.
Service not complete is the matter of the completion of service. Service not complete as it appear from the order of the Lozima Court. Matter of the completion of service. What is that? You are in item?
46, 47.
Service is complete.
My lord.
Is the service complete? So are you paying for all the respondents?
I'm for PNRD government. PNRD government.
You are appearing.
PNRD government.
What is the case about?
It's about,
This is writ petition.
Yes.
And the other 46, you are appearing.
46 also restriction, my lord.
46 service has returned back for respond number 9, 10, 11, and 12. Are you in 46? Okay, service not complete is the matter after completion of service. To 46. 47 also. Fresh steps was taken in respect of respond number 2, which was issued to the said respondent on so and so. However, when the matter was listed before the lawyer had observed that the ID card in respect of the has not been received by the Iman. And the postal track consignment report available shows
Service
that
is complete.
it has been returned.
Service is complete, my lord, because exponent number 2 is the finance department, my lord. We have already served the copy also. Finance
One number
department,
2 is the finance.
finance, my lord.
You have not served it to the finance.
Served, my lord. We have already served, my lord.
Have their names been shown in the cause list?
Yes, my lord. Shown.
Huh?
Shown, my lord.
Shown.
SC finance, yes.
SC finance shown. Yes. Taking into account that the service is complete. Item number 47. Matter be listed for admission after 4 weeks. Next. 49.
Lordship, in this case, we are required to file a reply, Lordship. So the affidavit in opposition filed by the respondent number 3, Lordship.
Who is to submit the amended cost title?
Applicant, Lordship.
Why?
Lordship, 1663 IA number, Lordship.
Why you have not submitted?
They file one.
My lord, we are implicated as party respondent, my lord, 8 to 12. My lord, in IA dispose of, my lord, as there is a my lord, typical error, that the applicant should file that cost title. My lord, they have filed the writ petition, my lord. How I filed my lord cost title, my amending their cost title, my lord. They filed writ petition, my lord. My learned friend filed writ petition.
Didn't this court pass an order that for the applicant to file?
That is,
So what is your problem in filing the cost title as per the applicant? You have sought for implement.
yes,
So therefore I gave you the responsibility to file the cost title. If you file the cost title, your name would be inserted.
my lord.
Then-
That was my lord. My concession was wrong, my lord. I think that was my lord.
When are you filing it?
My lord, on Monday, my lord.
Don't come up with this excuse. Because without the cost title, you cannot update in the CIS. So we do one thing. As you have not complied, we strike off your name. Your order to be cited. We review that order.
My lord,
No, we review that order.
I, my lord.
When there is a specific direction to
On
you to
Monday,
do this, which we remove this order.
On,
Here there is a specific direction. The applicants will file amended cost title within a period of 1 week from today before the registry. You have an interim order in your favor.
One-man committee is running, Lordship.
So as you have not done it, so a response number 8 to 12 is struck off.
I will, my lord, file, my lord, on Monday, my lord.
File it during the course of the day and inform before I write. How much time does it take?
My lord,
You have 4 names here and other names are already there. Just insert it by the computer.
my lord,
The counsel appearing on behalf of the newly implemented respondent numbers 8 to 12 submits that by Monday, the amended cost title will be filed. So taking into account the above, the matter stands adjourned to be listed again on 3rd of March 2025. In the meantime, the interim order passed earlier shall continue.
I don't
Obligation.
think, my lord. Interim order passed, maybe continued, but that interim was not continued, that is our problem. If interim orders continued, then also we need not.
First of all, I am not going to hear you anything.
Only that.
I fixed it in the month of March. You do whatever you will.
Oblige that. my
Item
lord.
50 to
Short date
50.
may be given, my lord.
Short date.
My lord, that is, my lord, as the case, it is regarding the society, my lord, hundreds of bighas of land, my lord, without any, my lord, cultivation.
Why haven't you done it? That order was passed long time back.
My lord, wrong assumption.
We have it in the month of April. I have not given anybody any date. 7th of April.
Sorry, my lord.
Where did you have? 10 February.
Obligation, Lordship.
10 February. In the meantime, you file your affidavit also.
Lordship, last order 12/24 may kindly.
What is this?
Item 50 to 52.
Done?
No, my
Lordship, the matter is with finance, Your Lordship. We have tried our level best. Even the Home and Political Secretary has wrote.
Mr. B. Devi,
Yes, Your
the learned counsel appearing on behalf of the respondents in the three contempt proceedings submits that the matter is still lying in the finance department and every attempt are there taken for the purpose of due compliance. Full stop. In this regard, he has also placed before this court certain instructions which are kept on record and marked with the letter Y and Z. Full stop. Taking into account the above, this matter again on 19th of December. In the meantime, the update be provided as regards whether the finance department has already cleared the amount.
53.
Better, I am appearing for all the respondents. Already appellant number for 2 and 3 I filed, 1 also I will.
The as doctor appears on behalf of all the respondents and submits that he would like to file an affidavit, isn't it?
My lord.
What is the order?
Order, my lord, relevant, my lord, page 46, paragraph 12. Regarding allotment of, my lord, dwelling houses under PMAYC scheme.
List this matter, list this matter again on 29th of January 2025. In the meantime, the respondents shall bring and record their affidavit.
Of 54.
Yes, what is this, Mr. Saad?
Earlier pass an order, that is page 19, may kindly be seen.
Eh?
Page 19, annexure 2. Lordship allow the petition for grant of extra payment to the petition. But when passed the order, instead of directing the joint respondent number 2, joint secretary implementation of Assam Accord, it was mentioned that the state of Assam is represented by secretary to the government of Assam Revenue and Disaster Management. This department was directed. So that needs some modification. And respondent number 2, joint secretary implementation be directed.
And what has happened?
Yeah.
You want the direction to whom?
The
Respondent number 2.
respondent number, Lordship, respondent number 2, joint secretary implementation.
Mr. A. Sahad, the learned counsel appearing on, Mr. A. Sahad, the learned counsel appearing on behalf of the petitioner, and Mr. M. Sethi, the learned counsel appearing on behalf of all the respondents. Full stop. Mr. A. Sahad submitted that the directions which was passed by this court in the judgment and order dated 29/2023, passed in WPC number 249/2021, can be effectively enforced if the directions were issued to the joint respondent number 2, that is the joint secretary implementation of Assam Accord Department, in as much as the said amount, the said ex gratia is to be paid by that department and not by the revenue department. Taking into account the above, this court observes that the that the directions which is contained in paragraph number 7 of the order of the judgment and order dated 29/2023 in WPC number 249/2021 to the Commissioner and Secretary, Government of Assam Revenue and Disaster Management Department be read as Joint Secretary, Implementation of Assam Accord Department, Dispur. Full stop. Accordingly, this court therefore the instant order shall be a part of the order dated judgment dated 29/2023 passed in WPC number 249/2021. With the above, the application stands dismissed.